So I have taken consent from the other side, Lordship. Case may be fixed on any other date, Lordship. Number 18th.
Any other date when? After?
After 2 weeks, Lordship.
Okay, MSN Chaudhary, the learned counsel appearing for the petitioner submits the praise for adjournment of the matter for 2 weeks, which is not opposed by the counsel appearing for the other side. Let the matter be listed after 2 weeks.
And Lordship, interim order is there.
Interim order so passed earlier shall continue till the next date of listing.
Obliged, Lordship. Next date may be fixed, Lordship.
2 weeks.
Obliged, Lordship.
Yes.
I will beg to mention item number 22. It's a bail application matter.
Hmm.
Miss Manjuli Dev, the engaged counsel is not present today. So may kindly fix it for the Friday, 22nd of May, if possible.
Friday,
Yes.
Thursday, we can fix it. Probably.
She's not here on Thursday or next week.
Next Monday. Friday, we have some other matters fixed. Okay, on the prayer of you are Mr.
R. Singh.
R. Singh on behalf of MS M. Dev, the conducting counsel in the instant matter. Let the matter be listed after listed on next Monday. That will be on 25th. Let the matter be listed on 25th.
Deeply obliged.
May it please your lordship.
Yes.
Regarding item number 28,
Hmm.
The petition is otherwise on interim, but perhaps case diary is not available. By.
Yes.
Is it not yet received? Why? It's I mean, it's not that far off.
One
Lordship, give us a time, Lordship, first week of June, any day.
Okay. MS the learned APP appearing for the state respondent submits the case diary in the instant case is yet to be received. Mr. S. Nawaz is present for the accused applicant. Let the matter be listed on when?
June
10th of
June, my lord.
June. Why so? No, I mean, we can't keep bail matters pending for this thing. He's enjoying his this thing.
Interim.
5th of June, yes.
5th of June.
5th of June.
I'm deeply obliged.
5th of June.
May it please your lordship. Lordship, I beg to mention item number 21. I'm appearing for the petitioner.
Hmm.
The engaged counsel is facing some medical emergency, lordship.
Okay.
Can it be fixed on 2nd of June?
Mr. So-and-so, the learned counsel appearing on behalf of Mr.
T.R. Sharma.
T.R. Sharma, the learned counsel, who is having some medical emergencies.
Lordship, I am appearing for the
Praise for adjournment of the matter for 2 weeks.
Lordship, interim order is there.
Mr. So-and-so appears for the respondent and he doesn't have any objection to the prayer made. Let the matter be fixed after 2 weeks. Interim order so passed earlier shall continue till the next date of listing. Yes.
Please, your lordship,
Yes.
with the consent of the other party, I beg to mention item number 16.
Item number 16.
Yes. Respondent number 1.
You are appearing for whom?
Respondent number 1, lordship. I have some personal difficulties, lordship, today.
And for the petition, my lord, item 16.
16. Okay. On the prayer of MS so-and-so, the learned counsel appearing for the respondent, which is not objected by the counsel appearing for the petitioner, let the matter be listed. When do you want it?
In, if you like it.
After 2 weeks,
After
lordship.
2 weeks. Let the matter be fixed after 2 weeks. Interim order so passed earlier shall continue.
My lord, I want to say one thing. This item will be listed under the heading stay matters. This item 16 is listed under the heading stay matters. But I think Ms. IA is already disposed.
Yes, I mean, so a lot of matters have been wrongly listed. No problems, it will go.
Yes.
There are a couple of matters are there which are for stays. That's why it has been listed like that. Don't worry, nothing will happen.
Okay.
It will come in the admission only.
May please your lordship. I beg to mention item number 14, my lord. And for the petitioner, my lord. In this case, my lord, scan copy of TCR is called for, my lord. Perhaps it is not available, my lord. Item 14.
14.
Yes, my lord.
Okay. You are Mr.
MAI Hussain.
Mr. M.I. Hussain, the learned counsel appearing for the petitioner submits that though TCR in the instant case was called for, the same is yet to be received. Full stop. Let the matter be listed after 2 weeks.
There is an interim, my lord. That may be.
Interim order so passed earlier shall continue till the next date of listing.
Hurry up, please.
May I please your lordship? With the consent of other side, I beg to mention item number 5, my lord.
5.
It's a, I am appearing on behalf of B. Chaudhary.
Hmm.
He's have some personal problem today. So matter may be fixed Tuesday, my lord, next Tuesday.
I am appearing for the petitioner. I'm for the petition.
Okay, MS so and so, the learned counsel appearing on behalf of Mr. B. Chaudhary. B. Chaudhary for a respondent. For the respondent. Praise for adjournment of the matter, which is not objected by the learned counsel appearing for the petitioner. Let the matter be listed when?
Your next Tuesday.
Huh?
Tuesday, next Tuesday.
Okay, 26th, huh?
Deeply obliged.
26th.
May it please your lordship, I beg to mention item number 2. Your lordship, with the my senior counsel, Mr. B. Chakraborty is in bereavement. We have taken permission from the other side. So your lordship, it's a humble prayer to kindly fix this matter after 2 weeks, or your lordship may.
Who is in bereavement?
No, my senior counsel is in bereavement.
What's his name?
Mr. B. Chakraborty.
Okay,
Oh, I cannot have any objection on this.
We have taken permission from the other side.
okay. Your name?
My name is A. Khashnobish. A. Khashnobish.
A. Khasnobis, the learned counsel appearing on behalf of Mr. B. Chakraborty, the learned conducting counsel for the petitioner, submits that Mr. B. Chakraborty is in bereavement and prays for accommodation for 2 weeks. Full stop. Mr. S. Datta, the learned senior counsel, appears for the respondent. Prayer is allowed. Let the matter be listed after 2 weeks.
Deeply obliged, your lordship.
May I please, your lordship. Lordship, may kindly allow item number 23 for withdrawal, for withdrawing the matter, lordship. The liberty to
23,
file-
what happened?
Lordship, we will file a fresh petition with the grounds were not properly taken in this petition. We will file a fresh petition, lordship, by withdrawing the instant petition, lordship.
Item given,
Item 23, lordship.
scan copy was called for lordship that received.
It has been received, right? What grounds you have not taken?
Lordship, the notice of 4748 was taken, but it was not taken properly, lordship. I will file a fresh petition with the proper grounds mentioning in the petition, lordship.
Without. Okay, Mr. D. Medhi, the learned counsel appearing for the accused applicant, submits that he has instructions to withdraw the instant bail application with a prayer to allow him to file a fresh full stop. The matter is dismissed as withdrawn.
Deeply obliged.
May it pleases your lordship, I beg to mention item number 20.
Item number
20.
20, yes,
We are the newly engaged counsel, lordship.
Hmm?
So we are the newly engaged counsel in this matter.
newly engaged.
So we have not received a copy of the IA. It was, in fact, it was served to the earlier counsel, so we seek for 2 weeks' time, lordship.
You are appearing.
We'll serve them a copy.
You are appearing for the applicant.
There
Okay,
is also an interim order, lordship.
okay, MS so and so your name?
L. Izung on behalf of G. Bodola.
So and so appears for the respondent, submits
For the
That-
petitioner. We are
for the petitioner, but in the application you are respondent. Okay. Submits that they have been newly engaged in the instant case and needs some time to take instructions. Full stop. See, further submits that a copy of the IA has not been served and hasn't been received by her as yet. Full stop. Prayer for adjournment is allowed. The learned counsel appearing for the applicant is directed to serve a copy of the IA during the course of the day.
May fix a date. Fix a
After
date.
2 weeks.
2 weeks, any date, your lordship.
After 2 weeks.
Right.
Yes, Mr. Dhar.
My lord, this is regarding illegal construction of some floors over a building which is more than 30 years old.
What is the longevity of your RCC building?
That has not been informed. We have
Hmm?
filed RTI.
No, otherwise, with general knowledge, with the tradition, with the,
It's a,
I mean, if this, all these things are available everywhere
yes.
publicly, that what is the longevity of a RCC building?
That is not been disclosed by the municipal authorities. We have filed application.
Mr. Dhar, that is not, I mean, municipality is not required to probably give you the information. That's a specialized information you can get everywhere. I mean, like, you can get it from, I mean, it's there in the public domain also.
But it depends upon the initial permission.
But usually,
Initial permission, if it is given for G+2 and it is intended to extend it more than G+5,
no,
G+4.
that merits will go later on. I'm just
No,
asking in
I'm just
general.
saying that
I'm just generally asking, what is the RCC building's longevity? Otherwise, people, I mean, if it is 30 years or 40 years, then people stop buying flats.
That is the question. And that is
Because
the-
I mean, I think it's usually it is taken as something around in between 60 to 100 years, depends.
Depends.
60 to 80, 60 to 80 or 50 to 80, something like that.
But the question is.
No, it depends upon the condition of the house,
Yes,
obviously, like
how
how
it
it is, how
it
it has been constructed,
constructed,
plinth of the house,
and whether
materials used.
it can sustain the load of another 2 floors.
Absolutely.
That are the questions. But respondent municipal authority has filed an affidavit without annexing any documents. They have not replied our RTI application. They have not responded to the order passed by this honorable court on 22nd of December 2021 to give a status report. That has not been done till date.
But you have been given an hearing, right? You have been given an hearing.
That we have disputed. That earlier two orders have been passed. One order is passed on 5th of January 2022 and pursuant thereto, they have annulled this order and passed another order on 19/1/2022. There we have been shown that we have consented for construction of another 2 floors over the building. That is not correct. We have given a representation. Immediately we come to know after this 19/1 order, but that has not been responded. That is
Who is
why
appearing for the private respondent? You are appearing. Okay.
and that is why we filed an RTI application on 25th of January 2022 itself.
Where is that RTI application?
Page 26, Annexure 18.
Page 26.
Yes. Additional affidavit.
Petitioner number 2. Petitioner number 2 has bought the house sometime in 2021. Correct?
Petition, yes,
2021.
yes,
So 5 years back.
5 years back.
Yes, where is that page?
Running page, Lordship will find page 80.
Page 18.
Running page 80.
18.
80.
80.
Yes. Prior to that,
Yeah, 80 is something else.
no, my lord, prior to that, page 78, this order was passed.
78.
This order was passed by
Huh.
the municipal board. That time municipal board was there. Now it is municipal corporation. They passed this order on 5th of January 2022 and page 79, your lordship, I will not travel with entire order. Second paragraph, the form 15, form 17, form 20, form 21 submitted by the structural engineer shows that the proposed construction 3rd floor and 4th floor is permissible. Thereafter, on considering structural ability and report thereof, the construction permission as prayed for may be issued with the following terms and conditions. The terms and conditions are there. Now, on 5th of January 2022, they allowed for construction of 3rd and 4th floor. But prior to that, they have already constructed.
They started constructing, that
started
is correct.
constructing.
That was a mistake they have done,
Yes.
committed. That is a
Now
mistake done.
on 13th, here it is.
So
written-
initially it was G+2, correct?
Yes.
G+2.
Yes.
Then they started constructing on third floor.
Third floor.
Then some objection raised by you.
Yes.
Then they applied for third floor construction. Third floor was given to them.
That is not there. We know with the neither. the
I think
respondent-
third floor was initially third floor was permission was given for third floor. Then dispute again happened. Then probably they given permission for third and fourth floor also after inspection. That is
Actually,
that is their version.
It is
Their
their
version
their
after
version.
inspection of
There
the
is
building and
some-
report.
There is some conflict in the affidavit filed by the municipal board, because if your lordship takes up the affidavit filed by the municipal board, page 89, running page.
So in 89 they say, if you come to you come to page 91.
91, yes, lordship.
91 from the bottom,
Yes.
I mean, somewhere in the bottom part.
Yes,
And it says that she stopped all further construction work and immediately applied for permission for third and fourth floor
yes.
on 4/10/2021. So when did you buy the house?
We purchased the houses on, just a second.
Petitioner number 2 bought sometime around 2021.
21, and petitioner number 1 purchased in 20.
So immediately after purchasing, you started
They started construction.
Constructing.
The landlord.
The record
if-
shows that respondent number 7 constructed G+3 RCC building on her land by obtaining construction permission. And see from Silchar Development Authority
May I
on.
just read this paragraph only.
Ah.
On receipt, it starts on receipt of the letter dated.
Where?
Page 91,
Yeah,
on somewhere. in
on
the
receipt,
middle.
yes.
On receipt of the letter dated 30/10/2021.
Hmm.
The respondent number 7 submitted a representation on 3/11/2021, stating inter alia that she constructed G+3 multi-story RTC building on her land, which she purchased by deed number so and so dated 7/8/1991 by obtaining due construction permission from Silchar Development Authority, and she started further construction without any construction permission.
Correct.
Unknowingly, and further stated that she was out of station, and on receipt of the order, she stopped all further construction work and immediately applied for construction permission for construction of third and fourth floor on 4/10/2021. Now, if we take up annexure 8, that is at page.
Annexure 8 of
8
your petition.
Of my petition. Read petition. Kindly see the date. Page 57.
This 30/10/2021.
Yes.
Yes.
So,
Notice regarding stop of work.
yes.
It has
If-
been issued to on 21. Okay.
30/10/2021.
30/10.
And the municipality on affidavit,
Applied
They
for
say-
permission on 4/10.
yes.
Yes.
And on 30/10, they issued this letter to the notice to the landlady and the landlord. With reference to the above, you are once again directed to submit all the documents pertaining to your ongoing construction as such land deed, building construction permission issued by any authority, competent authority, for verification within 3 days from the date of receipt of this notice. Also, you are directed not to continue any further construction work on the scheduled plot until any further instruction delivered from this end. So
Correct.
on 30th of October 2021, if she applied for permission on 3rd of October 2021, why did the municipal authority issued this notice on
They
30th?
issued this notice because the permission was not given till that time, at that moment. At that moment, on 30th, there was no permission given. It was only application was there. So once they verify the things, once they go through the papers, they will do proper site inspection, There is no permission.
Yes, but
That is why on 30th they have given this.
They
You
have
show-
asked for the
now
documents.
you show me if there is any document, I mean, when they have given this permission.
no, by this order, they say, this impugned order, they say this or permission was allowed. And 2022,
On
on 19/1/2022.
19/1/2022.
Yes,
Yes.
page 82. Page 82.
Yes, page 82 is subsequently.
Yes, 19/1/2022.
So they applied, so their version is that they applied for third and fourth floor permission. And they have inspected the spot, the
Yes.
place. Then after, on the basis of the report, I mean, basis of some structural engineer, whatever,
Yes,
his report, they have given the permission. What is wrong in that?
these reports are never been supplied to us. This RTI application we have applied on 25th of January 2022,
January
Yeah.
2022.
page 86.
Hmm.
If the municipality is clean,
Hmm.
then they could have filed all these things. I could have withdrawn this application, petition.
Page.
Page 26, 86.
86. 86 you have shown me. Yes, sir.
Request for information under the RTI Act.
So this was not replied to.
This was not replied to me.
Hmm.
And I have a strong belief that there is no form 15, 17, 20 and structural evaluation for granting permission. Because once they granted permission on 5th of January, they annulled that order. Then again on 19th of January saying that I was present, I have given consent, and I have immediately when I came to know about this order, I responded that I was not given any consent.
So 25/1 RTI application, what have you sought for?
RTA application.
What have you sought for? What are the information you
Yes.
have sought for?
Lordship will find page 86, copy of the
Page 85, then what are those documents you are looking for?
page 86, Lordship.
86. Kindly provide me the following information.
Copy of the inspection report of field assistant as
Hmm.
stated in the order dated 19/1/2022.
Okay.
Whether any NOC permission for construction of additional floors, third and fourth floor in so villa has been given to the Manashi Bhattacharya.
So that has been given already by this impugn order.
No,
The impugn order was
no
passed.
NOC has been given till date.
No. I mean, this passing this order. What is the requirement of an NOC when there is a order passed by them giving permission?
This order is passed pursuant to the
Hmm.
complaint given by me.
Correct.
This is not in connection with their application. This is in connection with case number 713,
Okay.
2021.
Hmm.
This order was passed in my case.
Hmm.
Manik Chandra Lunia complainants, Sri Gopal Chandra Chakravarti complainants versus so and so. This order was passed on my complaint. No separate NOC was given. Whether any structural evaluation was made by the authorized competent personnel to ascertain the structural integrity of the said building before commencement of the construction work of additional floors. If such evaluation has been made, copy of the same should be furnished. Furnish a copy of Form 15, Form 17, Form 20, Form 21 submitted by the structural engineer showing that the proposed construction of third and fourth floor is permissible in the aforesaid building as stated in your order dated 19/1/2022. So my case is there is no document to show that actually the permission was granted. Even if later on, they have started commence the construction work, nothing has been done by the municipal authority. That is my case. If they show any document, I will withdraw this writ petition. But in the affidavit, there has made some contradictory statement that I will not submit here before your lordship at this stage. Because report was called for by this honorable court in 2021
Hmm.
from the municipal authorities. That has also not been given to this court.
What report was called for?
Page 30,
Order dated?
order dated 22nd of December 2021.
22nd of December.
December 2021. Page 72. Page 74, relevant part. The last paragraph. On the returnable date, that is 28th of January 2022, the chairman, so Silchar Municipal Board, Silchar, respondent number 4, the executive officer, Silchar Municipal Board, respondent number 5, and Silchar Development Authority, Silchar, respondent number 6, shall place the status of construction of those 4th and 5th floor in the Silchar Villa located in ward number so and so, so and so, so and so.
They only asked for the status at that point of time.
That time status, but till date, we have learned nothing after elapse of nearly 5 years.
What is your instruction?
My instruction is that they have illegally constructed, they have obstructed the common areas of
Parking
this
area.
common area also.
Hmm.
I have photographs, but let them say at first on the basis of which permission they allowed such construction.
Okay, so your grievance is basically the required permissions as per the provisions of whatever.
Yes.
That is not available.
That is not
And without those things, they have allowed them to construct the building
construct
without any permission.
without any permission.
And
without any
the order
clear-
was passed stating that permissions have been given, but no
Given.
documents are available.
Not the documents have been given,
And RTI was also not replied to.
not given. This affidavit by the respondent number,
So they have not annexed anything, any
no,
documents.
no, nothing.
They have only simply annexed the order.
Nothing. They have not even annexed any order.
Acha, this was annexed by you in a reply.
Yes, 27th of January 2026, this reply has come from the respondent number 3 Municipal Corporation. That is also not complete. They stayed up to 5th of January 2022. They don't even know that they have passed an order on 19th of January.
Hmm. What are these Form 15, Form 17, 20, as per which this thing?
These are mentioned in their order.
But these are from which, which rules or what? Form 6, Form 15?
These are structural to evaluate the structural strength of the building.
Yeah,
They're from the structural engineer of the municipal concerned authority.
the Form 15 of what, which rules, which regulations or guidelines?
Building
Building,
rules,
bi-
building rules.
Building?
2014.
Building? Building rule of what?
2000,
That is my lord, this is the areas. In exercise of powers conferred under section 1 and clauses 11 and 14 of subsection 2 of section 301 of the Assam Municipal Act. Read with section 20.
Okay, Assam Municipal Act, building bylaws,
This is called building rule. ma'am.
building rules.
These rules may be called Assam notified urban areas other than Gauhati building rules 2014. But in regard to these form 13, 14, my lord, 15, 17 and all that,
Hmm.
that is possibly in the structural design that will be there. But in the fitness of the thing, what I feel, my lord, the matter can be remanded back. Let them, whatever my learned friend has said, whether municipal authority has complied with all these things or not.
The
Whether
only
they-
thing is that, see, his grievance is only that permission was not properly given. So the documents will show, do you have the record with you?
Not there, therefore, my lord,
And affidavit
will
also, you have annexed.
that, my lord, whatever they have said, we have written that way only. But then they will have their record in their office. If opportunity is given to both the parties, my lord, they can produce all these things, my grievance of my learned friend regarding that the fresh permission was not given. That also can be looked into because the first permission was given way back in 1998 by the Development Authority.
That was earlier.
That was earlier. Now, my lord, these areas come to the municipal corporation.
He cannot dispute earlier permission because otherwise his roof will also
My
go.
roof will also go.
Contention is that when you want to make a further construction, you must take a fresh permission. That's very correct, my lord. Because after 1 year it get lapsed. So therefore a new permission is required. Now, whether those permission are there or not, in that case, my lord, the municipality by here.
So that is very simple, Mr. Datta. That could have been if an affidavit can be filed and we can look into it.
Again, if we take time, what will happen, my lord, there will be.
Then again he'll have to approach. I mean, if he's then again he'll have to approach.
That if it is sent back, my lord, it may be easier for both the parties. I think my learned friend cannot have any objection to that.
I can understand the anxiety of the
No,
citizen.
he doesn't have an anxiety. Anxiety is yours.
So the records will not reveal anything. That is the anxiety my senior is. Then again, I'll have to come before this honorable court. And this person, the petitioner number 1 is 74 years old at the time of 2021.
Lord, I can assure your
I think the respondent is also an old person.
My lord, I can assure your lordships, my lord, if it is done, my lord, unauthorized way, then they will have to dismantle it. Law is this, my lord. There is no hide and seek business, they will have to dismantle.
Lordship.
And this one number 7 will have to reply whether how they have obtained permission or not. If they haven't obtained permission, then we'll have
You
to-
have not filed an affidavit. Why? No, forget about instructions, mister. Have you filed an affidavit or not? Why? No, why you have not filed an affidavit? Permission was granted, you could have brought on record. Where is your permission? Where is your permission? You should be having a copy of the permission, right? Where is that? You have it, place it before this court. Place it before this court right now. Then we'll dismiss this petition. You give it, give it before court. Forget about 9. When I'm asking about whether for the floor of 3rd and 4th, if you have a proper permission from the municipality board, the case ends. If you have it, you just place it before the court, I'll dismiss this petition. Why you haven't filed the affidavit till now? This case was filed on what? A specific direction is required to be given. You are the main contestant, one of the main contesting party. Your house will be, your floors will be dismantled. Wait, your floors will be dismantled. And you are saying that if no, the direction has been given to you to file an affidavit. You don't want to contest the case. You want the case to be allowed. No, they are not required. They are not required. When the case was filed, it was not sold. You have illegally, the allegation is that you have illegally constructed and very quickly constructed the house and you sold it off. They have already sold off. So what they can do, they have complained. They will, being aware what they will do. Let him bring on record.
And municipality authority.
Municipality also file an affidavit.
Yes,
Bringing all
File an
those things.
affidavit. Just bring those records. If it is there, there. If it is not there, not
Then
there.
I have
Mr.
the
Datta, you
choice.
cannot help it if it is not there. Cannot help it.
Action that
Let him file. Let him
Yes.
file an affidavit. Let him file an affidavit.
fresh permission is there or not, I will ask them. If it is there, send the original. file.
Correct. You just file an affidavit,
yes.
small affidavit. I mean, short affidavit. Both of you can file it. You bring on record. If you have the permission, there is no issue. He
Then
doesn't
I
have
have
any
no
case. He
case.
doesn't have any case.
That
But if you do not have it, then there'll be issues. Then of course, like he has sold it off. Then again, you'll have to think about.
Since 2021, I am running pillar to post to get those permissions. And My RTI has not been disposed of till late.
Okay, we'll give them some opportunity to
Minor.
file affidavits in the case. Okay, heard Mr. A. Dhar, the learned counsel appearing for the petitioner. Also heard Mr. S. Datta, the learned senior counsel appearing for Silchar Municipal Corporation. Yeah. Silchar Municipal Corporation, respondent number, you just take it down. And Mr. D. Mozumdar. D. Mozumdar for respondent number 7, full stop. The okay, Mr. N. Das for said respondent, full stop. The case of the petitioner is basically that in the concerned RCC building, the third and fourth floor of the building have been constructed by respondent number 7 without proper permission from the municipality board, stroke corporation, full stop. It is seen from the records that though the petitioner had filed an RTI application seeking for those permissions, those were not provided to him, full stop. In view of the, and there is no record to show that such permission is available or not, full stop. In view of the aforesaid, the Silchar Municipal Corporation, as well as the respondent number 7, are directed to file their respective affidavits by bringing on record the permissions so granted by the municipal corporation for construction of third and fourth floor of the concerned RCC building.
Along with these forms, they have referred to.
Okay, along with the inspection report, along with the inspection report that has been mentioned in the impugn order dated
19/1/2020.
19/1,
1912.
1912.
19/1. I'm sorry, 19/1/2022. Page 80.
19/1/2022. Just bring those things on record. Let the matter be listed when. Sometime in 9th of June. 9th of June will do. Okay.
Obliged, ma'am.
Fix it on 9th of June. 9th of June. Okay.
My senior is on legs. The item may be
Who is your senior?
Amit Goel.
Hmm?
Amit Goel.
Where is he?
CR2.
Which court?
CR2.
Huh?
CR2. Courtroom number 2.
CR2. Okay, pass it over for time being.
For his case in court number 1, once it
No,
starts.
this is a small matter. We'll take it up. You send somebody else. Hmm?
And that is a legal aid case. That is
Because they are saying that there is an order already passed in similar facts and circumstances and similar issue. So issue is very small. So we don't want to keep it pending. So that's why we'll just take it up. I mean, if something is there, we'll accommodate you. Don't worry. Hmm? Mr. Sharma, the records have come.
Fault is on my part, though the record is sent, I should have sent the order of this honorable court also. They have sent the record of the miscase number 9 of 2021.
That's something else.
The record your lordship has directed to produce the record of doc number 844 of Patna number
Correct.
133.
Because that is the disputed
Yes,
part.
lordship, but I have written the letter, but I have not annexed the copy of this honorable court. So maybe it's the fault on my part. Maybe.
Okay, so there must be some confusion about that.
Maybe lordship, but they have sent the records, but this is pertaining to 9 of the 2021-22 miscase.
Okay, Mr. Sharma, we'll allow him some time because that will be required. I think.
Yes.
That will be required. Mr. Saikia, some time will be given to him. Okay. Heard Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. B. Deori, the learned counsel for the petitioner, Mr. R. Saikia, the learned senior counsel assisted by so and so for respondent number. Mr. Saika is for respondent number 6.
Yes, yes, Lordship.
Respondent number 6.
May I?
Also heard Mr. H. Sharma, the learned additional senior government advocate for respondent number 3, 4 and 5. Mr. Sharma submits that Mr. Sharma prays for some more time to produce the entire records pertaining to DAG number 844 or Patta number 136, full stop. 2 weeks time is granted. Let the matter be listed after 2 weeks.
Much okay.
7 and 9.
Mhm.
May it please the Lordship.
Yes,
Lordship, I'm appearing in item 7.
you are appearing in,
Item 7.
I am for the petition item 8. I am. Yeah.
yes.
Lordship, these 3 items and writ petitions pertain to
Mm.
Kachar paper mills and the dismantling of Kachar paper mills. Unlike other tenders where there is a technical bid and a price bid,
Mm.
the way it works in this particular bid is that there's a pre-qualification requirement. So there has to be a tender for a technical bid, followed by, if I qualify the technical bid, then there is auction. So there is no price bid. So you create a pool of technically
Correct,
qualified.
pre-qualification and
and
then
you
you
have a
are
price bid.
eligible
Yeah,
to participate
Absolutely.
in the
Yes,
auction.
yes, that is how
Correct.
it is. So there's no price bid.
Mm.
So there were 20.
Now, you have, Decca appearing for whom?
I'm appearing in, for AIDC in item number 8 and 9. However, I have also instruction to appear in item number 7.
Okay, you are
But-
appearing for AIDC.
Yeah, and we are led by Lordship, Learned AZ. He is on legs in court number 5. However, he has requested to continue with the argument and he will join us, Lordship.
Okay.
I'll start.
Yes, yes, yes.
So Lordship, the auction notice is dated 7/8/2025.
Hmm.
Lordship will find that at page 18.
Auction notice in page 80.
18, yes, your Lordship.
Yes,
And Lordship may see the timelines.
page 80.
Page
Yes.
18, yes, your Lordship.
Hmm. Yes,
So there was an inspection date 10/10. We had to upload 15/9/25.
1 second. Page 18 or 80, you're saying?
1/8, 1/8,
1/8,
annexure
yeah.
2, sorry, your
1/8,
Lordship.
1/8, yes, yes. Page 18, yes.
So it's dated August 7th, August 2025.
Hmm. So inspection schedule has been given,
Yes.
schedule time, start date, okay, given, schedule auction is on 13/10.
10,
So you get almost 2 months of time,
yes. And then
okay?
15/9 is when I have to upload.
15/9 is, okay,
2025 is when
okay.
I have to upload.
Closing date, yes.
Yes,
And, yes, and documents required,
yes. Documents required. Lordship may kindly straight away go to page 44.
page
but-
44, it's not mentioned here.
Not here. So Lordship, these are the documents, page 44.
Document upload start, okay, document, seller, okay. Page 44,
Yes, your Lordship. This is where the problem arises.
page 44,
Yes, your
okay,
Lordship.
yes,
This is B, which is the pre-qualification eligibility criteria.
correct.
So Lordship,
So
number.
you don't have any issues with your finances, right?
No.
So
No,
you
no
don't
problem
have-
with 1, no problem with 2.
2,
The problem is with 3.
3. Safety
Safe
qualification criteria for bidders. Hmm.
Bidders must have a OHSAS
Hmm.
certification and shall meet the safety requirements as per seller safety terms and condition attached herewith. Lordship may now turn to page 81, which is the impugned rejection. Why were we rejected?
Yes,
Lordship has page 81, annexure 5.
yes.
It's from
So you have been
MMSTC?
disqualified, basically,
rejected because my ISO certification is expired before the auction advertisement date. And Lordship may note, auction advertisement date is 7/8/2025.
Wait a minute, like page 44 says.
Reason for
No,
disqualification.
Page 44 says, bidder must have OHSAS. What is OHSAS?
It is. Lordship. we
What
come
kind
to-
of certification is
It's-
this?
It's a safety. Lordship.
No, no, safety means where is that?
79. Page 79 has the full form and
Page
the
sev-
certificate.
Page 79.
Yes, Your Lordship. It's occupational health and safety management system.
Page 79.
Yes.
Okay. Occupational health and management system. Okay. Hmm.
It is like an ISO certificate. It is basically a certification that I have all the requisites to provide and dismantle safely.
No, no, occupational health and safety management certificate and OHSAS must be different.
No, Lordship may see the footnote.
Hmm?
Lordship may see the footnote.
This
Four.
certificate.
Four.
Huh? Footnote where?
Footnote 4 of page 44. You're on page 44.
Hmm. Footnote
You know,
4.
when Lordship at 3, it says bidders must have an OHSAS.
Certificate and
Yes, the
sell.
footnote 4 will explain to you that OSHAS corrected to
correct.
OHSAS on so and so.
Yes, OSAS corrected to OHSAS.
And page 79 is this affidavit, is this certificate, sorry. Lordship, there's no dispute about this, the contents of this.
No, we
and the
just
cer-
want to, we just want to understand
Yes,
this
yes.
because it says OHSAS. OHSAS is corrected to OHSAS. No, ISO certificate is a different certificate, right?
Yes, but.
So ISO certificate, I mean, now here rejection, they are saying only saying ISO.
Yes. Lordship, it's the same. This is to certify occupational health and safety management system, which will be OHSAS.
So basically you're saying that these two certificates were not available with you.
One
I mean, that is their allegation.
Certificate, one certificate.
One certificate
This
when
is
was not
certificate.
available.
Yes. Lordship, we now come to page 81, which is the reason for rejection.
They are saying rejected as the ISO certificate is expired.
And that certificate, your Lordship will find at page 79.
So
Expired.
ISO certificate is expired, they're
Yes.
saying.
Yes.
So your certificate,
Lordship may see the date.
certificate date is 25/5/2022.
Correct. Lordship.
Valid
and
until 24/5/2025.
And the advertisement was 7/8/2025. 8/2025.
7/8/2025.
So on the date when we submitted this certificate, it had already expired. It had expired in May and we submitted in August. So therefore they said your certificate is expired. So we immediately wrote back, your Lordship. This we got. Lordship may come back to page 81 and see the time, 25th September, which is the date for uploading. 25th September, 9:24 p.m. We got this and
So the 25th September, you received it.
yes, the rejection.
And
we replied it-
uploadation date was 7/8/2025, right?
Uploadation date was 15, I think.
Closing date was 15/9.
15/9, yes, your Lordship.
15
We uploaded
September.
it, but you uploaded the wrong.
You have, correct, you have uploaded a wrong
Yes, yes,
certificate, then on after 10 days, 25th, they have
They
written you
discovered-
back, rejecting your qualification,
yes.
right?
And Lordship may kindly turn to page 82 now.
82, so you wrote back to
Yes,
them.
and we wrote back the very next day at 1 o'clock. So less than 24 hours. And we say, Lordship, the bold bit,
We have attached,
here with the latest OHS certificate, which is valid until 23/5/28, already available to us. And that you'll find at page 80. So it was an inadvertent error. And Lordship has page 80. Now Lordship may look at the date. No, wrong.
Yes.
Valid until 23/5/28.
Certificate date is before the.
We meant to upload this, but we uploaded the wrong one. So it's not like we did not have this qualification. Because of inadvertence, we uploaded the expired one. And it's not like we did not have it on the date of advertisement. This is a historical document. The certificate date is 24/5/28. And your Lordship will remember it's 7/8/25 is the date of advertisement. So on the date of advertisement, I had this valid certificate until 2028. And this happens to be what is known as typically historical document.
Yes.
And we came to your lordship's court, and by way of an interim order, we were allowed to participate.
Hmm.
And we participated, and we are the highest bidder.
Hmm.
That is the position as it stands.
Hmm. Hmm.
And lordship, our argument is that we meet the qualification because of inadvertence, and this is the only reason, there's nothing else. And that is undisputed. It's not like there is any other thing that we missed.
Hmm.
AIDC's stand is that you gave an expired thing, and therefore we are not supposed to look at anything else, and you're out of the race. And our submission is that it's a historical document. It was an inadvertence. We have the qualification. We immediately brought to your notice. So therefore, you ought to have considered us and let us participate, even without intervention of the court. And lordship, for that, I rely on one Delhi High Court judgment, MDC. MDC. Because it puts it nicely. What is also going to be my submission.
Okay, okay, we'll look into this. Let's give it to me. And like, after you wrote back to them on 26th September, right?
Yes.
Then
26.
what was the reply? They didn't reply anything.
No, we did not get any reply.
They didn't respond anything.
No,
Hmm?
we came
Nothing.
to court. We came to court. And on 9, my interim order too? 9/10, we got an interim order, allowing us to participate.
26th of September, you wrote back to them saying that you already have a valid certificate, but inadvertently you could not submit it, maybe by mistake or whatever. And
And submitted that report.
after that, there was no reply from them. And then you approached the court.
Yes, your lord.
And you got an interim relief
Yes, on 9/10
for participation.
for participation.
And what is the status of that Kachar, this thing now?
There's a stay by your lordship.
Lordship may look at the interim order
Yes.
for the moment.
The
9/10. There's a stay.
Stay for what? Everything?
Yes, your lord.
Everything.
We had to deposit, since we are the
Where is the stay order?
9/10. No, it is first to, yeah.
9/10.
9/10.
Okay.
9/10. Lordship has 9/10, that's the first order, which allowed us to participate. And lordship.
The whole thing is stayed.
Yes, your lordship.
Okay.
We are the only parties who are out of pocket 4.4 crores.
Okay.
Because we had to do the pre-bid deposit, and because we are the highest bidder, so our money is the only money that is retained.
Okay, what is the ratio in this case?
MDC.
MDC, yes, your lordship.
Which paragraph you are referring to? Paragraphs
Lordship, paragraph 10, 11, 12.
10, 11.
12. Here, exactly
12.
similar situation. They had to give ESIC challan to prove that they have been paying employment provident funds. They again gave the wrong ones. Lordship, paragraph 10, 11, 12 will give you the facts. May I read 10, 11, 12?
Yes.
The petitioners, in accordance with the tender conditions, also submitted ESIC challans to show that it was regular in making payment of its ESI contributions and dues. On 6/7/21, the petitioner was informed by respondent number 3 that the bids of the petitioners were found to be ineligible by the respondent corporation for the reason that name and code of the firm differ in ESI challan. So they doubted their payments. Against the rejection, the petitioner company submitted its reply on 12/7/21, explaining its stance and providing clarification that the petitioners was not in arrears or default of payment of ESI dues of its employee serving at its head office Chandigarh and its factory and works at Baddi, Himachal Pradesh. The petitioners also state that the ESI challans of past deposits are historical documents which pre-existed at the time of tender opening and could be examined to establish the fact that the petitioners were not in arrears of ESI dues. Since no response was received of this letter and since the petitioners continue to be treated as ineligible, the petitioners filed the present petition.
Okay, we have understood your case.
The findings are important. Paragraph 43.
Paragraph 43.
43 and 49, your lordship. 43 is good enough. Because they rely on their own previous order.
Yes,
Lordship has page 43.
yes, yes.
We have held in our decision so and so, the tender authority should not have a myopic view. Its objective should be to encourage maximum participation in a fair manner. And I rely on this. Therefore, the tendering authority which issues a public tender should ensure that each decision should be made bearing public interest in mind. The TEC, while considering and evaluating bids, cannot act in a mechanical manner. It is not a post office or a mechanical computer and comprises members, highly intelligent and qualified people who are experts in their fields. They're expected to sift through information in a reasonable manner and apply their minds to the same. They are to evaluate tenders to derive maximum benefit and should keep their ultimate goal in mind, which is, in the present case, is welfare of the workers. Additionally, it should be kept in mind that the purpose of tender is to get maximum participation. This is what I heavily rely on. The purpose of tender is to get maximum participation and not stump bidders on hyper-technical grounds only because the examination of their bids requires some application of mind.
Correct.
And Lordship, I'm the highest bidder. So if I was out,
So yeah, you
AIDC
are the
would have
highest
been
bidder with what was your quotation price?
90 crores.
90
Actually,
crores.
Yes, Your
And
Lordship.
who was the second one?
Yeah,
You don't have that figures with you, right? You won't be having it, yes.
Seal envelope.
Yes, seen envelope. Okay, that is your case.
That is it.
Okay, yes, AIDC.
Yes, that. I am also one of the petitioner in this case.
Oh, you are also there?
I am also one of the petitioner.
Huh.
Item 9.
Item number 9.
So with regard.
Item number 9.
No, 5.
Thank you so much for point.
8.
Thank you, 7.
He wants to say some points in item
Item number 7, we'll just place one.
1 second.
No,
1
one
second.
second. No, you please judgments, but lately place, then it will be easier for you also.
Both the cases are actually on different footing, Lordship.
Wait for a minute.
Yes.
We'll let the petitioners finish first.
And for
Then
one of the petitioner,
then you will get the
then it
opportunity.
will be easier for them also.
Item number 9, Mr. Das is there.
Yes.
Yes, yeah, the
I am
same,
appearing.
same case, similar case?
My lord, yes, that's the same, the tendering process is the same.
Okay.
But there are few.
And
things-
you also rejected for some
No,
certificate.
I came a bit of later before this honorable court.
Hmm.
When all this proceeding was pending before this honorable court,
Hmm.
there was one of the party which came up before this court when my learned friend Goswami client came to this court, and their case they projected is their edifice. So what I have heard that there was rejected because the last date of submission of the bid, when the particular it was uploaded, it was a particular uploaded is an expired document. It was uploaded. Then they approached the court. Court said it's a historical document, so you please allow them. And ultimately, financial bid, what they said that they were the highest. In the meantime, one of the bidders came up before this course, and in that matter, there was a stay which was granted. Subsequently, that bidder was withdrawn, and when all this proceeding was pending, then we entered into this case. We were also, my lord, our case is what we are projecting. Your lordship was asking a very pertinent question here. What I was hearing it, the certificate, OHSAS. Your lordship was asked, what is that certificate? This is an ISO, but we brought notice to the court. We said this ISO certificate, OHSAS, is an obsolete, which is obsolete in the year 2021. 2018 it was obsolete, but there was a grace period of 3 years it was given up to 2021. Now that certificate is no more. When terms and condition, they were floated terms and condition, your lordship has seen pre-qualification criteria, they have mentioned OHSAS. OHSAS, full form my learned friend has explained, this is what it requires. ISO safety norms.
So basically ISO is an organization
a-
which gives lot of certificates to
now-
lot of companies. So different
Now
ones.
that is obsolete and there is no more.
Hmm.
Now it has been replaced by a new certificate which is called OHSMS. So the edifice, my lord,
Has submitted that.
that certificate, when they uploaded, that was their case before this court, OHSAS. The court said that you had that historical document.
I'm sure the court was not aware of OHSMS. Now there is,
Because Goswami was showing was always SMS, not the other,
but if
not the
you
other
see
one.
the terms and condition, pre-qualification criteria, there's OHSAS. So they have never said that this certificate has become obsolete. So it has been now whatever, because when the tender was floated, auction was 2024. By that time, that certificate has become obsolete. When you have auction, that auction, if you see, that was dated of 2024. By that time, you did not have that OSSS certificate. And what you have done, if you see pre-qualification criteria, and if you go down, and if you see they have corrected, there was a corrigendum.
Yeah, footnote, they have corrected it.
They have, what they have corrected?
They've corrected to the obsolete one only.
That's right. So they have corrected an obsolete one. So now, your lordship, why we entered into this case? We entered, and I will show one order passed by this court in a particular matter. They said there were 20 bidders. Out of 20 bidders, 3 bidders came into, other was all rejected. All rejected. Now, if you allow edifice who did not qualify on the last date of submission of bid, that means the portal which they have uploaded wasn't expired. Means expired means expired. Then what will happen to other bidders? Second chance. Then you are giving a second chance. By virtue of the court's order, you are giving a second chance to them. So can you give it? Whether it will be a violation of Article 14 by exclusion of others. When you are treating, you have to treat it equal. See, my lord, the Diaram Shetty's comes into play. There are other judgments come
So
into play.
your case is basically what?
My case is that, number one, you could not have allowed. If you have allowed, you have to allow all others. Number one. Number two.
So you're trying to block
What I'm saying, why not a re-auction? Why not a re-auction?
So your prayer is what basically?
Give option, give all bidders equal opportunity. Why some defective?
And how you were disqualified?
I was not disqualified. Number one, I made a last date, which was the last date of submission. Before that, last date was 15/9.
On third
of
September.
September 2025. I wrote an email to them. Please look into that email at page 88.
No. Tell me one thing. Why you were disqualified?
Because I was not. I didn't participate.
You did not participate. You did not participate in the tender itself.
Yes. I'll say why. Why I will give an answer to it. Why I did not
No,
participate.
Mr. Das, I mean, you have not participated.
No, no.
Participated or no? Okay,
No,
give
please,
me
I'll
show me
see
the
page 88.
Page?
88. 88. PC 88. No,
Yes.
I'll just draw your lordship attention to page 32. Please see first 32.
Page
30. 30. Please see 30.
Page
first.
30.
Let's go by one by one. Please,
Okay, page 30. Okay.
30. Lordship got it?
Yes.
Please see catalog view date is 7/8/2025 on the top. 7/8/2025. This is a date. Now, inspection schedule is written there.
Yes.
Schedule auction close date is 13/10.
Yes.
Right? Update closing date is 15/9. Now, please see the what is at page 32. That is a description. Page 32. Dismantling and demolition. Nature of job.
Yes.
Now, please
The
see
scope of work. Yes.
scope of work.
Yes.
Now, please see 33.
33.
33.
Yes.
And see the third line, last date for receiving queries. On the top.
33.
That page
Okay.
33.
Any query?
Any query, clarification, so and so. Last date for receiving queries at AIDC through
392025.
39 up to 17 hours.
And he wrote on 392025 to them.
2000, yes. Please see my email now.
Yes, 392025. I can see that.
25, but please see 27 minutes late. 17.27 at page 88.
Page 88.
88, that's my email. 3rd of
7
September.
5 o'clock, 27 minutes past 5 o'clock.
Yes,
So you wrote to them
yes,
and here is 5 o'clock.
yes.
So
Now, so that's what 27 minutes there was a late.
see, this is any query, clarification, PQC
Yes.
can be sought by buyers by sending email from buyer's registered email ID,
Yes.
seller's email ID. Is buyer is required to be registered with them? The address is how they
MSME.
get to know the who is buyer?
STC.
Huh?
STC portal. They should be registered in the portal, Lordship.
Correct. So have you registered earlier?
I don't know, my learned friend instructing
Well,
counsel, he will,
please clarify whether you have registered or not.
you please inform them.
If you are not registered, then you don't have any case.
I don't know, that's I don't know, he will be able, let him get a query,
Because
but
see, Mr. Das, usually what happens.
I know that your lordship will ask 2 questions here. First, your lordship will say, you have not participated, so what is your right? That's your question, my.
That is one thing. And
Yes.
and the most important thing is that like usually in this kind of auctions, what happens is that like you need to register.
Yes.
Correct. So if you are not registered, a Tom, Dick and Harry cannot write to them.
No. If you don't register, the end of the matter.
End of the matter.
Your email will not count also.
Correct. That is
Now,
why I'm
two
asking.
things, second email will not count. You are late by 27 minutes, that's a different where they have to explain why you have not explained, why they have not entertained that email.
Correct.
But what the friend said,
It's
that
registered.
it is registered, right?
So show me a document whereby you
Show
can
me
say it's
document.
registered.
If necessary, my lord, a small affidavit can be filed also.
That can be done because that will be important.
That's a very important.
Important.
Suppose you don't register yourself, then you don't have a right to send an email to you.
Correct.
Email.
Correct.
So,
Because they are not
now-
going to see each and every email.
Now,
Hmm.
why we came,
Hmm.
my lord, before this court?
Yes, yes.
Now, please see at page 91.
Page 91.
Yes. 91.
Yes.
90 is the order of this court. What you got it?
Yes, yes.
Now, please see. My lord, I'll just read this order.
Hmm.
Paragraph 2, my lord. If I am permitted, is at page 91.
Yes, please.
Pursuant to the order passed by this court dated 9/10/2025. 9/10/2025 is the order at page 95. At page 95. Please see that.
That is in your petition, right?
No, in my petition, I have annexed this. 9/10/2025.
No, that order was passed in your case.
My order, this order.
Passed in
was
which case?
edifice. Yes, edifice.
Okay.
They are referring,
Hmm.
the court is referring to the earlier order of 9/10.
Okay.
9/10. Read that order?
Yes.
Read that order? 9/10?
910, yes.
Yes. They said that order says that kindly see at page 96.
Hmm.
First, let us read 9/10, my lord, order.
Hmm.
Then see page 96.
Hmm.
The learned counsel for the petition, my lordship got it?
Yes.
Paragraph 8. By referring to the provision of detailed auction catalog, more particular class B pertaining to pre-qualification eligibility criteria submits, bidder is required to possess an OHSA certificate.
Hmm.
Lordship got it?
Hmm.
And the same was required to be attached along with the bid.
Hmm.
Mr. Goswami, so and so, learned counsel petition submitted. While submitting his bid, the petitioner has inadvertently uploaded a copy of the OHSA certificate which has expired in the meanwhile. See, submit the responsible author in view of the submission by the petitioner an expired OHSA certificate proceeded to reject the bid of the petitioner via an email dated 25/9/2025. Petitioner on coming to learn that inadvertently expired OHSA certificate was so uploaded, preceded email dated 26/9/2025 to submit the valid OHA certificate available with the petitioner. However, the same was not considered by responsible authority. Now, pausing for a moment. My lord, there cannot be any certificate of OHA certificate. There has to be a certificate of OHSMS certificate on the date when it was moved by this, before this honorable court on 9/10/2025. That became an obsolete.
No, it has become obsolete from when? Since when?
2021.
2000?
We have annexed. We have.
2021. Then
Yes.
how can there also authorities issuing that certificate?
That's what we are saying. What we are saying, they have not issued. The case projected in edifice was that historical that document we had. But while uploading, it wasn't expired. OHSAS was expired. So what? Terms and condition has been shown before the court while moving the matter. Court said that yes, these are terms and condition which has been corrected, making OHSAS corrected. So the projection, what the learned court while passing this interim order was thought that yes, you are having the certificate, but somehow it expired, but you possess that certificate. So that will be allowed.
Yeah,
That's-
that was a prima facie case made
Prima
out for
facie,
interim. There
right.
is no doubt about this.
Yes.
Hmm.
Now, 1 second. Now I will show it why this is an expired.
Hmm.
If your lordship wants a quick answer to it, that what is the position, how it got expired, this certificate and how it is obsolete, please see at 1-1. Please see 113 first. 108. 108 plus see 108. I'll show to you this court what is this, why this petition was entertained while moving this honorable court. 108. See, my lord, this is nodal agency to regulate National Accreditation Board for certification bodies.
Yes,
So
yes.
these are nodal agency. Now please see one ISO so and so on OHSMS has been published in March 2018. The requirement standard has been published by the International Organization for Standardization so and so so and so. This standard specifies requirement of for an occupational health and safety OHS management system with guidance for its use to enable an organization to proactively improve its OHS performance in preventing injury and health.
No, yeah, Mr. Dasle, we have taken, I mean, we have accepted what you have said that this is not, I mean, that has become obsolete.
Yes.
Now, if it is taken as you have stated, but what is your case?
My case is that
Hmm.
my number one.
And what did you want to?
There are two arguments. One
See,
is that first
huh.
is you could not have included this clause.
Hmm?
OHSAS
Hmm.
that has become obsolete.
Hmm.
So whether it is there or it is not there, that it has become obsolete.
Hmm.
So you cannot bang on that clause itself.
So AIDC has committed a wrong.
Wrong. So
By giving, I mean, giving in pre-qualification that he should possess a document which has already become obsolete.
obsolete.
Correct.
So
So you are
somebody-
saying so.
Yes.
Hmm.
If you have written
Hmm.
that this has OHSMS
Hmm.
that is required, then of course, my lord, we will be out from the fray.
Hmm.
As we came to know later, when this proceeding was going on.
So that your case is that only.
Yes.
That there is.
My lord, how I will participate?
Hmm.
I cannot participate when
But let me see your email that you have written.
Yes.
Have you raised the issue?
Yes. Kindly see at page 88, my lord.
Yes.
I was in a bona fide belief that OHSS exists.
My lord will.
Yes, 88.
Yes.
Huh.
We fulfill your eligibility criteria. I
Hmm.
thought what, my lord, that was existing
Hmm.
of one average annual turnover and experience. You also got it?
Hmm.
The 3rd of September 2025.
Correct.
Please see first, second, third, fourth paragraph. We fulfill your eligibility criteria of one average annual financial turnover, experience demolition, dismantling of more than so and so. However, we do not have had a OHS certificate as it is not required in our field. Even so and so nature of work do not require including tender of so and so so and so. Auction. Therefore, we can request to allow us to participate in the auction. If we wish, we are declared so and so, we'll dispense only from a contractor who has so and so. Because, my lord, what we are under bona fide believe that this certificate was required. But subsequently, we discovered that by virtue of this, if your lordship now looks into at page 108, that has become obsolete. So there was no occasion of the tendering authority to
But
put
how
that
to,
particular.
that's like, how can you write a letter to them on the on after the expiry of this thing, stating that I do not have this certificate, but I'll engage someone
No,
who will be having a
no,
certificate.
it's okay, my lord. My lord, that's we have written. Ultimately, they have not given reply. Ultimately, they have not given reply.
See,
They may
basically,
not give a reply.
you have not participated in the
Yes,
in the process,
yes,
right?
That's right.
Secondly, you whatever little bit of right you think that has been created or may be created in your favor is this letter. Nothing else.
Oh, no, what I am saying.
So what this
No,
letter says,
Please, now you please see, my lord, at page 94.
Yes.
Please see, sorry, see, please,
page
see page 91.
91.
Yes.
Yes.
Please see 91 and paragraph 2.
Yes, this order, let's. this
Pursuant to
order.
the order passed by this court,
Hmm.
so and so, on
Hmm.
behalf of respondent number 2 and 3 has placed before this court in seal cover
Hmm.
the rates received from the participant bidder in auction process. Same has been perused and returned.
Hmm.
The learned standing counsel appearing on behalf of so and so. This court has also taken note of the affidavit in opposition filed by respondent number 2 and 3, wherein the minutes of the meeting dated 24/9/2025 has been enclosed. From the said minutes of meeting, it is seen that out of 20 bidders, only 3 bidders have found to be qualified for participation in the auction bid. Petitioner herein was also held to be not responsive. Be it as it may, by virtue of the order passed by this court on 9/10/2025, petitioner was allowed to participate in the said auction process. Now, my lord will kindly see paragraph 4. A question duly arises as to whether the sanctity attached to the minutes of meeting dated 24/9/2025 survives within the ambit of Article 14 of the Constitution of India, when out of 20 bidders, only 3 bidders were held to be technically qualified, and this court, via an order dated 9/10/2025, only permitted 1 bidder to the exclusion of others who were similarly situated. That's the point where
How they are similarly situated?
similarly situated means, my lord, if you have allowed edifice, you have allowed edifice where they did not.
Edifice was allowed with
No, you did not have the certificate on the last date.
Correct, but they I mean, see, edifice's case is little bit different than others.
No, what I'm saying.
So you see, Mr. Das, your case is that you, I mean, you don't have the certificate. You wanted to engage somebody, and you wrote in the after expiry of the time. Correct.
Yes.
You have wrote a mail to them saying that I'll engage somebody who has a certificate. You stand in a totally different footing. You have not participated at all.
Right.
And edifice, prima facie, whatever. I'm not talking or like commenting on merits, but edifice is showing a document that which is already there with them, which was already there with them, but somehow they did not submit the document.
Yes.
And they say that this is the document, this is a valid document, which is still available with me, and it was issued to me prior to the auction date. So that is why you please consider this. And looking into that matter, and a order was passed for them to participate in the auction process. And I don't think anything.
I'll give a 2 quick answer to it.
Correct.
First answer which I'll give it, that edifice case is different. Well, edifice case, what the learned judge in this page 92 paragraph 4 is saying, that if you have allowed edifice, my lord, the virtue of the court, they were rejected. They were rejected.
But
No, I'll
Mr.
just
Das,
give an
Mr.
answer.
Before you tell me one thing, let me tell you one thing.
Yes.
But do you want to say that like thousands of people are there who may be eligible, but they have not participated in the bid? Do you think all these people will be taken care of by the court?
No, it's not what I'm.
And say that like, okay, we allow all the people to go and
This
participate.
is not what the court is saying. Court is saying 20 bidders participated.
Correct.
The question here is 20 bidders participated. Out of 20 bidders, 3 has qualified. Now, a virtue of the court's order, edifice was allowed that yes, he will be allowed to so far as to consider this document, which is historical document. But the entire issue is whether edifice was acquiring that certificate on last date where it was uploaded.
That is a matter, Babin.
No, that's what I'm saying, my
That
lord.
is a matter has to be looked into.
Technically, it was rejected.
That is a matter. That is
now
a matter.
your lordship may ask one thing to me. What I'm putting myself, what is your right? Why you are after edifice? What is your case? That's what your lordship is putting it.
Your case is based on para 4.
No, my case is based. My lord, if that be the case, that email should have been replied by me by saying, number 1, no, we will not consider this your case because there is no question. If I am in the portal, it was
Yes.
if I am in the portal. If I am not in the Empanella portal, then out of this frame, my lord. There is no question, your lordship will reject outright. If I am in the portal, then it was the duty of them to give a reply. They did not give a reply. I did not come on time. That's let us be honest to it.
I thought that
I
did not have that
But
certificate.
now,
How will
now,
they
my
apply
lord,
it?
your lordship knows that where is that certificate which has become an obsolete, which this has become an obsolete. What they could have done it by a corrigendum instead of OHSAS, by a corrigendum they should have said no, it is OHSMS. Then there is absolutely no problem. Why they have not mentioned that OHSMS? Now what their affidavit say? They say it is the same genus. They OHSS and it's the same genesis. How can you say the same genesis? Mala, am I clear to your lordship, Mala? Well, I know that troubling your lordship is what is your right to come up before this court. What is your right to come up before this court? And your email is saying that no. If some other contractors, if I get it H1, then I'll engage some other contractor. That's what lordship's view of an email. Now let us for a moment forget of the email.
Yes,
And
that aspect also has to be seen whether you can engage somebody else after getting the contract.
My lord, what is it is almost, my lord, kindly see. What is the difference between edifice now came up and saying that no, we have what certificate you are having? OHSMS. You did not have that OH, it was not required. My lord, on the last date of submission of the bid, that was not required at all. Meaning what, my lord? There is no question of any certificate. My lord, there is no certificate to be submitted because that has become an absolute and obsolete certificate. My lord, kindly see, they correct it. And what manner they corrected it? Please see the correction. OHSAS. Why they have not corrected and they not mentioned OHSMS? They did not correct it. So we could have immediately rectified.
Yes, then they'll have to reply.
And the stand taken in one line, they have taken a stand. Kindly see in page 127, their stand. Please see affidavit in opposition filed by AITC. Please see their stand.
Yes, page
With
one.
regard, see the last two lines. With regard, para 27, last two lines. With regard the OHSA certificate, it is stated OHSAS and so and OHSMS are the certificate of safety forming the same genus, and therefore respondents allowed bidders who possess either of the certificate. How can you allow either of the certificate which has become obsolete? Can you allow it?
We could have participated.
Then how can you allow it, my lord? Either of this certificate, obsolete certificate you are allowing someone. Can you allow which is not a part of terms and condition of the NIT? It is not a terms and condition of NIT. Now they are taking a plea, my lord, here, saying that it formed the same genus. OHSS and OS form the same.
They are saying that like this is issued by same organization ISO, and they forms basically basically relating to safety norms.
My lord, OHSMS is a higher safety norms.
OHSMS is a higher safety norm.
Higher safety norms.
Okay.
Higher safety norm. That's why it has become obsolete. And the objects sought to be achieved is safety norms. Now, what they have done, they have in OHSMA is a higher safety norms. That is the object sought to be achieved. We can't say that this certificate is not.
Let them. I mean, we'll ask them what is the how it is higher, how it is this not. I will ask.
We have annexed those documents.
Not a case. No, my lord, that's my case, my lord. Whether I am in the portal, your lordship, that's it too. I don't know, my lord. I don't have anything on record.
ID. Yes, we have.
ID, I don't. They said it has. If they want, the affidavit can be filed. But I don't have a written instruction. Neither it is by an affidavit. If they can show it by an affidavit, you have to do it in affidavit. If that. Second question is that what is my right to come to this court at this stage? That your lordship has to take into consideration. My right. I have come belated before this court, but when the proceeding was pending, I came up before this court. And I have looked into, maybe your lordship may see that you are a fence sitter sitting or else looking the proceeding. Now you have come. But the proceeding was pending before this court. Proceeding was pending before the court. Then, my lord, there was an interim order that was passed by this court. Now there was a bid. Now your lordship will see.
In your case, what are the order passed?
Order passed, notice has been issued.
Only notice?
Notice has been issued. Notice that because already there was some interim order before. Come on, order before. Which order? Order passport is नहीं है. Notice?
Notice.
Please see the order. Oh, no, you need to.
312 order.
Yes.
12 March. 12 March. Again, prior to that, there is one more order.
There is one more order prior to that also, I think. We made edifice as a party. We made edifice also a party, my lord, here. I think they didn't choose to appear in this case, my lord. They definitely, my lord, it's their prerogative, my lord. A writ petition has been filed by them.
Had they mentioned, I would have immediately participated.
Right. But this is my case, my lord, in short.
So you are basically, I mean, as per this interim order, you, I mean, not interim order, I mean, the initial order,
Yes.
so you're basically saying that this, since that certificate has already become obsolete,
Yes.
that could not have been,
That's what terms and conditions.
that could not have been a
And you cannot take a plea affidavit. There is either of these two certificates, if you have, is the same genus, forms the same genus. Either of these two certificates you have, then you could have participated.
That's little bit of movement of wrist they have probably.
Now, my lord, maybe there are few judgments of the Supreme Court, but the principle which has been laid out by the Supreme Court, that what my lord, Dairam Shetty, Afcons, then Vinishima Technology Private Limited, these are, please see one judgment. The principle that has been laid down by the Supreme Court is 2025 SCC Online SC 2119. Court number 103 or 7. Huh? Paragraph 20, just reading one paragraph, my lord.
Paragraph 20.
Yes, I am done, my lord, one paragraph.
Yes.
Paragraph 1. Such a restriction therefore cannot be justified reasonable within the meaning of 19C of the Constitution of India.
I'm
The
sorry,
state-
para
para 20.
20.
Para 20.
20.
Such a restriction therefore cannot be just or reasonable within the meaning of 19C of Constitution of India. State, while it enjoys the freedom to prescribe the condition in the tender, cannot exercise that power in a manner that infringes upon constitutional guarantee by closing the market to outsider without just cause. The doctrine of level playing field requires the gates of competition be opened to all who are equally placed. Impugned tender condition exclude the competition and experienced suppliers who may have executed contract of far greater magnitude in other state of a central government department from participating in a tender and has the impact of promoting cartelization. The impugned condition operate as a closed door to outsiders and restricts the wider participation of bidders and restrict competition. Impugned tender therefore is violative of Article 14 and also offend 19(1)(g) of the Constitution of India. It's like closing it and forming.
We will place it on.
My lord, there is one, I have received this MSTC registration. Registration.
Okay.
I can't put it like this in across the court, my lord.
No, that is fine. I mean, if it is there, then
It's
we
there.
can, I mean,
It's there.
we can take,
I'll not trouble the
we
other
can
judge.
put on record.
Dairam Shetty and all those judgments are there, my lord, with principle as laid down. But that's my submission for this book. I'm deeply
Yeah.
obliged, my lord. More economic for the
Lord, I appear for the petitioner in item 8, my lord. I shall not waste a lot of your lordship's time.
Item number 8.
8, my lord, Vishnu Engineering.
Ah.
My lord, I shall not reiterate what my learned senior has
Now,
said.
your case is what?
My case, my lord, on facts is slightly worse than Mr. Das's case, my lord. I'll be very candid before your lordship. There was neither any clarification email nor any participation from the petitioner in this case, my lord. We take a case, my lord, that because of inadequate publication, my lord, there are several persons, including myself, who has not been able to even come to learn about the tender. And now when we take this case in our writ petition about inadequacy in publication, because, my lord, we say that it is 100 crores plus worth of tender, which is of a high value nature, of a high value tender, my lord, only published in the MSTC portal. And, my lord, the query that fell from your lordship, my lord, we have a document which we have annexed that we are registered with the MSTC portal. In the reply, my lord, AIDC does not dispute the fact that the tender was only published in the MSTC portal. They in fact reiterate that you being a member in the MSTC portal, you should have seen it. There is no question that you being a member are taking a point that I did not know about this tender, hence I could not register my participation. My lord, to that, my lord, our simple response is that, my lord, MSTC portal, my lord, MSTC portal, my lord, is one of such portals out of several, my lord, in which any persons dealing with scrap, my lord, this is scrap sale of.
Is there any guidelines
Yes, my lord.
issued by Union of India?
Yes, my lord. My lord, there are rules, my lord, of the Assam Public Procurement Act and the Assam Public Procurement Rules, my lord. The question was whether those rules are applicable, my lord, to this particular tender.
Because this is a PSU.
This is a PSU. My lord, we say that
PSU
that is
owned by central government.
owned by central government. So, my lord, the Assam Public Procurement Rules and the Act, my lord, are applicable is our case, my lord. That says that it has to be adequately published in 2 or more government websites. And it cannot only be one MSTC portal, as they say. My lord, so we say that it is also non-compliant.
Well, I'll just
Yes,
come
yes,
in 5
yes,
minutes.
yes,
If I just give me 5 minutes.
Absolutely. Yes, my lord. My lord, the first point being of inadequate publication, my lord, it is our case in the writ petition that if found inadequately published, my lord, it goes to the very root of the matter, my lord.
So you
Also-
you said Assam Public Procurement.
Assam Public Procurement Act 2017, my lord, and the rules framed thereunder of 2020. I have copies, my lord, of the notification, not carrying the act.
So you are saying that this act is applicable to
Yes,
this
yes.
this instant auction also.
Because, my lord, AIDC is a state organization.
ADC is only an executing body or whatever. I mean,
My lord, but the auction
nodal
perhaps-
agency.
the auction perhaps of Kachar paper mills was through AIDC being the seller. My lord, so I understand, my lord, in my limited understanding, my lord, it is AIDC and it is a state entity which is selling, my lord. So the Assam procurement rules governs all the sale made in the state concerning state exchequer. My lord, so if that be the applicability, the only next hurdle that I might have to cross, my lord, on Assam procurement rules, my lord, as the act is named procurement, which signifies taking services, and this is a case of demolition. My lord,
No,
that
that is
covered.
fine. That is fine.
That
That
is
is
covered
fine.
in
But
the
like
sense.
it's for only for Assam government.
Yes, yes, my lord.
Assam government
state
procurements.
State government
State
procurement.
procurements,
Yes,
right?
Yes.
The whether now you'll have to convince this court whether this is something which is procured
state.
by state of Assam.
My lord, when we took this point in our writ petition, they have used an affidavit. They do not deny the fact that this is not a state procurement.
Where is that?
My lord, we have taken this point, my lord, at paragraph.
Now you show me the affidavit, their affidavit,
Yes,
their
yes,
reply.
yes, my lord. Just gives me one moment. Lord. Yes, my lord. Para 24, my lord, at page 119, they deal with
Para 1,
para 24.
para 24.
My lord, they deal with my paragraph about applicability of the act. So simplicity denial are not correct, and it is denied that the tender process dated is wholly arbitrary, discriminatory.
Para 24, page 119.
119, yes.
Yes.
They deal with, my lord, my para 13 and 14, my lord.
Para 13 and 14.
Yes, ma'am. And my lord, if I may take your lordship to para 22, my lord, it's more clearer, a positive statement, if I may say. 22 at page 118.
No, your petition, para 14 and 13 and 14.
13 and 14, yes. But they actually do not.
You read para 13 and 14.
Yes, my lord. Paragraph 13, I say the petitioner states and submits that the entire tender process is wholly arbitrary, discriminatory, and violative of Article 14 and suppose.
No, para 13 of your petition.
Yes, that is para 13 of my petition.
Page 7.
What is this? My lord, just gives me one moment. There's some.
Para 13 is something else.
Is it page 6, Lord, in my copy? That is starts with the petitioner states and submits the entire tender
Yeah, that
process.
is the same in my copy, but it seems to be. What is the?
Is it petition number, Lordship?
Read petition number 6517 Vishnu Engineering. So what is your pleading on that?
My lord, I understand your lordship is at page 7, para 13.
Read.
I'll show that. My lord, then it would be page para 12, my lord, at the top of the same page. I apologize, my lord. There seems to be some. The petitioner states and submits that the notice inviting tender was never uploaded on the state public procurement portal, nor was any abridged notice published in newspapers as required under the Assam Public Procurement Rules 2020, which mandates such publication to ensure wide participation. By confining publication solely to the MSTC portal, the respondents breached statutory obligation and deprived the public of equal opportunity to compete. My lord, to this they use a reply.
This is not a PIL.
No, my lord, not a PIL. My lord, I say, my lord, that if this notification or these rules have to be mandatorily complied with, my lord, the notice has to be published in such manner. Now, my lord, in their reply, they do not dispute the fact. They instead say that MSTC portal is a government portal. Hence, I follow, which, my lord, I was showing from the reply to your lordship at para 22, where they say that MSTC portal is a government portal.
So there are two portals. One is state public
Yes.
procurement portal. One is MSTC.
MSTC.
portal.
So they say I've done it in
So
MSTC.
they have not published it in state public procurement portal, but they have done it in MSTC portal.
According to them. My lord, now if your lordship considers the rules framed under the act, what does it say? Does it specify MSTC or state public procurement portal? Or it
They
is
only say wide publication.
No, my lord, it says state public procurement portal and abridged in 2 newspapers. My lord, there are 2 requirements. My lord, if the act applies, if your lordship is of the view, my lord, that the act would apply to this particular auction, then it has to be mandatorily as per the statute, my lord, is my limited submission, which does not mention MSTC. Even assuming that MSTC is also one of the state public procurement portals in another nomenclature, my lord, even then it says abridged in 2 other newspapers. So, my lord, the second, admittedly in their reply affidavit, they have not provided any abridged form in any of the newspapers. So, my lord, I say, my lord, because of this, because of inadequate publication, the participation in the tender has been curbed. Coupled with, my lord.
No, but that is fine. But like as far as your case is concerned, you are already there in the portal.
I was there in the MSTC portal.
So you were aware how you are aggrieved.
Yes, my lord. So on the MSTC portal, my lord.
So you forget about others. You talk about yourself.
Yes, my lord. So my.
So your thing is that you are already
yes, my lord.
You are already there in the portal, right? You are a member of the portal, registered member of the portal. And obviously, I mean, as a wise businessman with a lot of wisdom, you should have been aware of what are the contracts coming in the portal.
My lord. That is why, my lord, I started with the fact that, my lord, my factual situation of not participating stands on a worse footing than what Mr. Das was.
Correct. So that is why I'm asking you. Then what is your case?
Yes, but my lord, one more case, my lord.
Because you have not filed a PIL or somebody.
My lord, but this is coupled with the second aspect of my writ petition, my lord, which is one is inadequate publication, my lord. The second is the tailor-made tender process, my lord. Because I say, even having not participated in the tender process, my lord, a bidder who has now come to learn about the terms of the tender, if I can show to your lordship that the terms were in such a manner framed that it was excluding wider participation, my lord. Your lordships in the writ jurisdiction has ample powers to look into the terms, my lord, as far as they curb competition or
So your
tailor.
case is only thing is that only thing is that your grievance is that this, as per the public procurement, this particular act
Yes.
and the rules framed there and there, then there should have been two more publications
In newspaper.
in the newspapers, and that hasn't been done.
That's
But as far as another contention is that this state public procurement portal is concerned, they are saying that MSTC portal they have already published,
yes.
and you are a member. You
Yes,
are a
I-
member and registered member there.
Yes, I will.
I mean, there is no, deprivation to you as such. That is their stand.
Yes,
That is
yes,
their
yes,
stand.
my
That
lord.
is their
Directly-
stand.
Yes, my lord, I
Yeah.
shall not, I shall.
And since this is not a PIL,
Yes.
this is not a PIL,
Yes.
so you can only argue your case,
Yes,
right? So your case is that there was not sufficient publication because the threshold is quite high.
Yes,
Threshold is 100 crores
100 crores
rupees
with high
compared.
value tenders as the.
High value tender, so as per some
Yes,
procurement. And you are saying that since AIDC is holding the auction,
yes,
so it's within the
State.
framework of state. So some procurement
Right.
rules and act will be applicable to
Yes,
your
my lord.
case.
Yes. And my lord, now the second angle, my lord, to this is the tailor-made terms, my lord. The moment I came to learn about the contract, my lord, yes, I did not participate.
Now,
Yes, I was not.
what is the tailor?
Yes, yes, my lord. If your lordship takes the pre-eligibility criteria once, my lord, your lordship
Hmm.
has already gone through them.
Page?
My lord, that is at page 40 of my writ petition. 40, page number.
40, yes.
My lord, B,
Hmm.
my lord, here it says, my lord, if your lordship straight away comes to 3,
Hmm.
which is safety qualification criteria for bidders. Bidders must have OHSAS certification
Hmm.
and shall meet the safety requirements as per the seller safety terms and conditions attached herewith.
Hmm.
My lord, this has to be read with page 41. If your lordship just sees 41,
Hmm.
which is an additional safety requirements which they specify. And if your lordship sees page 43, particularly page 43, just above the table,
Yes.
2 inch.
41, what did you want to show?
41 is the additional safety terms, which
Correct.
is to be read with clause 3 of the.
Correct. That certificate in addition to that,
Yes,
these
yes.
terms.
So
Yes.
this continues till 43, my lord. If your
Hmm.
lordship straight away comes to 43,
Yes.
just above the table,
Hmm.
to ensure highest standard of safety at the demolition site, the
Hmm.
following frameworks and guidelines published by different departments of the Government of India and other statutory agencies are to be adhered to by the buyer at all times. My lord, kindly sees numerical 2.
Hmm.
My lord, radioactive waste. My lord, this is admittedly a demolition of a paper mill. My lord, there are judgments, my lord, even the judgment which Mr. Das showed, one of the paragraphs I'll show, my lord, that there has to always be a rational nexus between the terms of a tender to the job that is being tendered out. My lord, that in that case also, in the facts of that case, my lord, the Honorable Supreme Court said that there exists no rational nexus between the terms which the tendering authority had placed.
It has
for-
been tailor-made for whom?
My lord, tailor-made to persons, my lord, it is my submission who had
This is what
certificates.
radioactive, what does it say? Regulatory control of radioactive discharges to environment and
Yes,
disposal and solid waste by so and so.
Yes.
So there are some guidelines given. If
Yes.
there is some radioactive waste, how it has to be handled.
Yes.
And what is the problem in that?
My lord, the problem, my lord, is there's no problem, my lord. There is only one submission, my lord, that this read with the specific pre-qualification eligibility criteria, including that OHSAS certificate, which was obsolete. My lord, the entire term is framed in a particular manner that only certain participants.
Now, you show me
And-
something
Yes,
in this radioactive waste which you cannot comply with or none of the bidders can comply with.
Yes. My lord, but before I could.
No, you answer me that. See, there are certain guidelines
Yes,
they have
Lord.
given
Yes.
as far as safety norms are concerned.
Yes.
Now, this is a demolition work. So there may be there may be hazards, there may be certain substances which is harmful to the surroundings as well as the environment. So they have stated that certain guidelines have been given in these portals regarding management of wastes.
Yes.
And while demolishing it, while handling those wastes, you'll have to follow those guidelines.
Yes.
This is what they have stated. And you are saying that this is tailor-made. Now, you show me one thing that by inclusion of this, they have tailor-made it to favor someone.
My lord,
So no, you'll have to answer that.
perhaps I have not been able to express myself correctly, my lord. If your lordship reads this again with clause 3, my lord, why I say this is because this is in addition to
Yes,
an already
There
OHSAS.
there is a requirement of getting a certificate from an international organization, that is ISO,
Yes.
which provides for safety norms,
Yes.
different standards,
Yes.
different units, different companies,
Yes.
or different spheres, whatever.
Yes.
Correct. Now they are saying you'll have to give this certificate. In addition to that,
Yes.
you'll have to comply with these
These guidelines.
guidelines. These are only guidelines.
Yes.
Correct.
Yes.
Now you are saying that like this particular clause has been tailor-made.
No, my lord.
So tailor-made means what? Tailor-made means that to
Something.
favor someone.
Yes.
Now you show me in your case that this has been done to tailor-made and favor somebody.
My lord, that is why.
No, that is your submission.
No, this is where, my lord, I just want to retract my submission in a better manner, my lord. I am saying, my lord, that when this is an additional to the certification, the international certification, which was obsolete on the day. This is my case, my lord, which was obsolete on that day. The additional regulation following or the compliances are additional to having a certificate. My lord, once the certificate itself is obsolete, and then a person with an OHSMS certificate, which is edifice, my lord, was permitted to participate, my lord, in this particular tender with the highest bid. When that particular
That was
certification-
due to court's intervention.
Yes, my lord, not because of that, my lord.
So
Intervention.
see, so please don't argue this that they have been allowed by AIDC to participate.
No, my lord.
They have been allowed by AIDC to participate because of the intervention of the court.
My lord, but in the reply affidavit, AIDC now has stated that all certifications of similar genus is applicable, and we were inviting everyone who would have the similar genus certificate to participate. My lord, with deepest of respect, my lord, kindly, my lord, clause 3 does not provide the word same genus, neither does it says that it is with regards to every other certification of similar nature, my lord. The court intervened as an interim measure, my lord, prima facie finding, subject to the final affidavits coming out from AIDC, my lord. In the affidavit, if the stance of AIDC would have been something else, my lord, it's a different situation. But
You are totally an outsider, first of all.
Yes, my lord, that
You are totally an outsider. Your only case is that sufficient publication was not there. So as far as sufficient publication is concerned, that has to be replied by AIDC. We will hear the reply.
Yes.
Correct. And as far as this thing is concerned, these guidelines and all,
My lord, I
I
understand.
mean, that argument that you have
Yes,
you have made, that it is tailor-made, but you could not show any particular material to show that it has been made tailor-made. So it doesn't convince me.
Right.
Let me be
Deeply
very
right. Yes,
let me be
Your
very
lordship.
straightforward. It
Yes, yes.
doesn't convince me at all. So only thing is that like proper publication, whether this act is applicable to this procurement or not, that they'll have to answer. So that's all with you, or is anything else?
But I just adopt Mr. Das's submissions on OHSS and OHSMS, my lord, because that I do not want to repeat.
That
my lord.
reply they have given that
Same genus.
because it's relating to relating to same genus of safety norms.
Yes.
So safety norms, since one certificate is obsolete, but other certificate has been given, that is sufficient. That's the employer is saying. Now whether
That
they are right or wrong, that has to be
your-
seen.
Yes.
Correct? That's all.
Deeply.
Yes, Mr.
Yes, request for some accommodation. Can I give my reply tomorrow, Lordship? Because I was in the midst of a very long hearing. It suddenly collapsed.
Okay.
So could it be given? I'll take 15-20 minutes.
You all are finished, right? You all are finished. MS Goswami or resigned, that's different thing, but otherwise you all are finished. Okay, we'll keep it for tomorrow then.
My lord, may I be permitted to appear virtually, my lord? I'm coming from Calcutta. Tomorrow it will not be possible for me, my lord. My learned senior friend would be on reply.
You can appear virtually, you can appear virtually.
Deeply obliged.
Okay, we'll write
Like,
heard
yeah,
MS Goswami Senior Counsel appear. Goswami is appearing as item number 7. No?
Yes.
Okay, we'll pass the order for tomorrow. You are appearing all the matters, right? For ADC. ADC, okay. MS Goswami for Learned Senior Counsel, assisted by Ajay Das for the petitioner. Then also heard Mr.
Karnani, my lord.
Karnani. Then item number?
Eight.
Eight. And item number 9, Mr. Das, Senior Counsel. And all the matters you write, Mr. D. Saikia, the learned, you'll be appearing as AG? Yeah, yeah. Advocate General, assisted by Deka for respondent AIDC. A Kakote for? Item 7, okay. Item 7, you're writing. Then on the prayer of Mr. D. Saikia, let the matter be fixed on the prayer of Mr. A. Saikia for a short accommodation, which is not objected by the council appearing for the petitioners, let the matter be fixed tomorrow. Tomorrow, that is on lead to deal. Okay.
Deeply.
I'm sorry, my lord, I was on legs before. My lord, item number 3. Which one? I don't know that. Third round of litigation, my lord. In the meantime, coordinate bench has delivered judgment in respect of same thing. In item number 4.
Coordinate bench says,
This honorable court has decided the issue that I will place, my lord.
This court has decided the issue?
My lord, not in respect of present petitioner, in respect of other petitioner.
Okay, where is that?
I have an next in writ petition.
Paragraph, page?
Page, my lord. It starts from 88.
Okay.
Before that, may I explain, my lord, what is the issue?
Yes, please.
My lord, in railway, your lordship, for construction, manufacturing of my sleepers, for the purpose of, my lord, that rail track, your lordship. Railway, initially railway 1991.
1 second.
My.
Yes, Mr. Goel, yes.
My lord. Initially, in the year 1990, 89 or 85, my lord, they used to allot land free of cost, my lord, for manufacturing purpose at their own site so that loading and unloading would be easier. Subsequently, they have.
No, you manufacture slippers.
Slippers.
So they, I mean, wherever the construction site is there,
my lord,
so they gave you certain land to do the construction
work.
And that was done free of cost.
Free of cost
At that point of time.
Subsequently, they have issued circular saying that now you have to pay lease license fees, and accordingly we are paying it.
So for the particular land,
particular land that they have allotted to us. But in the meantime, and that there is a circular which says that on the basis of the circle rate of 1985, it is required to be collected.
1985.
As per their circular. But what they have done in the my lord, ignoring that circular, my lord, they started demanding on the basis of present market rate. So accordingly, we approached the authority that this is a circular and all, that they did not comply. Then we approached this honorable court. This honorable court directed the authority to decide assess as per the circular. But despite that, they said that
that circular is still valid. It was not amended. Nothing has been done.
Some amendment is there, my lord.
So amended, but it doesn't amendment in the price, no.
Some conditions, man, not in the price. So as per the circular, they have.
So your basic problem is the price, right? Lease rate.
True, your lordship. What we are submitting, my lord, this coordinate bench also, my lord, held that it has to be on the basis of that circular.
That particular circular.
Particular circular. So accordingly, matter was remanded back to the authority to decide, but they have not done. And in the present case, my lord, they have deducted it also. That higher price.
Okay.
We have paid, but we approached this.
But there was a direction from this court.
Direction, this is third round.
Direction from the court to
reconsider it.
Reconsider
taking into consideration
in terms of that particular circular.
Taking into consideration.
They have taken the consideration. They haven't done so.
They have not done.
They haven't passed any speaking order or
nothing,
something like that.
Nothing. But they are saying that you have to pay by that rate and accordingly, that was that they deducted from our running bills, my lord. We have nothing, can't do it. So they deducted it. Then we approached this honorable court again. And in the meantime, this honorable court in the engineering case decided the issue in respect of same issue, your lordship, in respect of other contractor. They are also involved in the work of my lord sleeper construction.
Construction of sleepers.
Sleeper, your lordship. That judgment, my lord, first kindly see page 88. These are the facts, my lord. 88, it starts from 88. And my lord may kindly come to page 92, paragraph 5, last paragraph, my lord. It is in the affidavit in opposition.
Page 92.
92, my lord.
92, yes.
And last para 5, last line, last paragraph. In the said affidavit in opposition of the respondent railway, your lordship has got, my lord.
One second.
Last paragraph.
Page, paragraph, para 5,
Para 5.
last line.
Last line.
Last
In the
line.
said affidavit in opposition, at the bottom, my lord.
Bottom I can find, in the said affidavit.
In the
yes.
state affidavit in opposition of the respondent railway authorities, a joint engineering, commercial and account circular dated so and so, which is the master circular for licensing of the railway land for commercial plots is enclosed. Clause 6 of the said master circular stipulates as to what should be the license fee on the basis of land value. Clause 7 and 8 of the said master circular bearing relevant, which relates how to fix land value and what is to be done in the fresh cases of licensing of the plots is quoted herein below. Then, my lord, that relevant provisions were given. This honorable court, my lord, thereafter, a perusal of clause 7 would show that the market value has to be fixed upon the land value of the surrounding area as on 1/1/1985 as determined from the revenue authority. It has been categorically mentioned that the land value as worked out shall be increased every year on 1st April. So, as per the circular, we are not
So
disputing.
10% every
that we are
10% increase.
There are revision, my lord, your lordship may skip over and kindly come to findings of this honorable court. Page 96.
Yes.
The master circular to which railway authorities have enclosed to their affidavit of position dated so and so, apart from the above quoted 7 and 8, that in case of licensing, proper licensing agreement must be executed between the railway administration and licensor before the licensor is given the possession of the land and the plot. Thereafter, revision of license was there. Then in the backdrop, page 97. In the back, para 14. In the backdrop of the above, and after taking into consideration 3 circulars that I will show, my lord, a specific query was made to the learner standing on the railway as to whether there exists any licensing agreement with the petitioner. The Council for Railway, upon instruction, states that there is no separate licensing agreement. Here also, my lord, initially they executed the agreement, but they used to allot me the work, but that was not renewed. But they are asking us to give me land license. Agreement was not renewed.
The agreement for what?
For that land, your lordship.
Agreement for land. So you're saying work. Work is different.
Work is different. For executing work in that land, my lord, for manufacturing a sleeper, they allotted us work, but land
So
license.
this agreement is nothing to do with the construction of the sleepers. It's only with the land.
With the land for the purpose of construction, manufacturing. That there is no separate licensing agreement enter into with the petition except a contract agreement written long back here also, which was petition only the purpose of supply of PCS sleeper allotment of land was not at all related to the same. If further submit that the correct agreement of contract agreement of 1991, the land value was written, and from the 1993 to 95 petition has been paying the annual license fee, and the rate at which the license fee was fixed initially was rupees so and so. He further submits that there has been a yearly increase of license fee that we are paying. The record shows that the respondent authorities were though bound as per its own circular to enter into licensing agreement, but nothing has been done till date. It is also an admitted fact that the petitioner had paid the licensing fee for the year 2010 to 11 and 2015 to 16, which the respondent authorities have accepted without any objection. The record further reveals that without any notice, the concerned respondent authorities have issued the impugned notice of demand dated so and so, thereby directing the petitioner to deposit and some more rupees so and so on the basis of communication dated so and so issued by circle officer so and so so and so. This made adopted to increase the licensing fee is not only contrary to clause 7 of the master circular dated so and so, but is also contrary to clause 9, which stipulates how revision of the license fee has to be made in as much as the increase in the license fee cannot be more than 7% every year. By the impugned notice of demand, the respondent authority increased the licensing fee by almost 11 times for the year so and so, so and so. This fixation of land value and consequent licensing fee, which is in violation of clause so and so, so master is therefore arbitrary, unreasonable, and violation of railway own circular and liable to be set aside interpret with an observation that the respondent authority can fix the license fee in terms of clause so and so, so and so. The basic observations of this, my Honorable Court, is this. Accordingly, it was interfered with and directed us to enter into an agreement with the railway. Here your lordship will see.
So in this case, the Daya case, what about?
Daya engineering.
Daya engineering, was there any agreement?
Initially, there was an
No,
agreement.
no, later on.
Later on, there was no agreement.
After
but
this order?
After we entered into.
You have entered into an agreement. So
Yes.
this order was complied with?
Complied.
Hmm.
There is no appeal against this order, my lord.
Mhm.
This matter is squarely covered by this Honorable Court
Hmm.
order and the impugned demand, my lord. Master Circular, you also will see at page 54. Page 54 and relevant page 55. And 56, fixation of land value. 56. Clause number 7. So I comply the provision, my lord. What I am submitting, my lord. Let the matter they may assess on the basis of this master circular. And the impugned
Yes.
order.
Yes, they are saying it's a covered case.
In that particular case, lordship, there was no license agreement. But in our case, there was a license agreement. Subsequently, lordship.
No, the issue is whether you have license agreement or not. That's a different thing. Okay, it may have a license fee, but license agreement, but the issue which has cropped up because of the demand, right? So demand now, whether you have done the demand correctly or not, as per your circular or not. So if it is not as per the circular, then there is some scope of interference. But if you say it is as per the circular, then there is no scope of interference. So what is your submission on that?
Judgment also said that what is the what to do when there was no licensing agreement, and then it was observed that when there was no licensing agreement, they have to enter into a license agreement, and prior to that, how to calculate those periods. But in this present case, lordship, there was a license agreement, and they are up to
still valid.
No, we have asked them many times to renew that. Lordship, I have annexed those documents also, but it was never renewed. As it was never renewed, so we have asked them to deposit the balance area and also to renew it, lordship. And thereafter, lordship, apart from that land which was licensed with them, they are using another 7.05 bighas of land, which were for that there was no license agreement. So that part probably is covered by the judgment because there was no license agreement. But for that other part, lordship, that which are already there was an agreement for 8.3 bighas of land. So there is a difference between.
No, that's what I'm asking. So if there is a license agreement also, in terms of the license agreement, there has to be some increase year-wise or twice or whatever. I mean, there will be some frequency wherein they can enhance it. But enhancement can be done as per the master circular. The yearly you can do 7%, yearly you can do 10% or whatever. And obviously that license agreement will be in compliance with the master circulars. So now in your case, whether that has been done as per the master circular or not, that is the thing. So show me that.
So we have to take the view of that how to calculate the land value, etc. from the circle officer, lordship. In present case, it is from Ayang Revenue Circle, and before fixing the land value, lordship, those were done, lordship. And as after their report only and their calculation, the land values were fixed, lordship.
Show me that the license agreement.
License agreement, page 38, my lord. Initial agreement which we have entered.
But it was only up to
right.
90.
I already said. Page 38, initially we entered into.
So once the license agreement is not renewed,
my lord,
or it has already elapsed, what will be the status of this license agreement?
They fail to renew it, Lordship. We
No,
have,
no, both of you are parties.
Lordship, we
You
have,
can't say that like they failed.
Lordship, we have asked them to come and annex a
Why
Lordship.
did you allow them to carry on with the work?
Lordship,
If the
they-
license agreement is expired,
Lordship,
it has elapsed, why did you allow him to use the land?
Lordship, thereafter,
They collected fees also, my lord.
And you have been taking the fees also. It's not that you are not taking the fees. You are taking the fees, the license is gone, license is elapsed. So we'll have to treat it as, treat is as there is no license at all. So when there is no license, then, I mean, how it will be fixed? There's a master circular. In terms of the master circular, if you are not doing, that is his allegation, you are not
In the
doing it
interim notice,
as per the master circular, then obviously you'll have to take care of that.
Lordship,
See, an agreement has a time always, right? If agreement is not renewed, that agreement's existence is no longer there. That has become a nullity. And thing is that whether you, I mean, you are accepting money in terms of what? In some new rates you are taking. You are asking this, pay me this much of money as per the circle rates. That's what you are doing, right?
Lordship, and Lordship, Annexer A page 112 is our letter by which we have requested them to renew the license fee, deposit the license fee and also to renew it, Lordship. Subsequently, they replied that there is no necessity to submit any license fee. So as they
Where is that?
Page 112 of my affidavit. We have also asked them to vacate the land, Lordship.
This was in 1996.
Then they have replied to that there is some agreement with the construction organization, but they failed to.
Now, where is the reply? They say some new contract agreement.
Exactly.
Stated that there is a new contract agreement with the construction organization. So we, by the next page, next letter, in the next page, Lordship, we asked them to submit their construction agreement with the, but they can.
No, which construction organization? Construction organization, the meaning by what?
Lambding to and Divrugarh.
But they failed to produce.
1986, my lord.
No, what is this construction organization?
Gauge conversion project between Lambding and.
No, the new contract executed with the construction
For
organization.
manufacturing sleepers, my lord.
So manufacturing slipper is a different thing.
True, my lord, but we have to manufacture in their land.
Right. Understood.
This is the-
But you have entered into a manufacturing agreement with somebody else and you are using a different land.
By railway.
By railway, correct. But like for that, for that you don't have any license agreement.
Subsequently, my lord, your lordship will see.
Now, where is that such license agreement? Why didn't you agree?
In additional affidavit, my lord? Not there, maybe. But other agreements we have annexed, my lord, in the annex. Till my lord 2024.
Directed to produce that by this honorable court also, Lordship, but that was never
Page
produced.
110. That particular may not with us, my lord, but we have annexed other agreements.
No, see.
Now, thereafter, my lord, what has happened, your lordship? They used to issue us notices, and accordingly, in 2009, my lord, after this, my lord, lots of water, my lord, from my lord, they have deducted it from my running bills. that license fees as per the
But why you have not paid the license fee and
No,
reduced the
because they are
license?
demanding as per the current market rate.
No,
That's
no,
why
no.
I approached that.
No,
Your
no,
Lordship
no,
will see.
no, no, 27/6/1996.
They are saying, Your Lordship.
27/6/1996 letter you have not complied with. Why?
My lord, subsequently it was given, my lord. Amount has been given. In fact, my lord, we
Where is that?
approached this honorable court. There after page 77.
Page
77, my lord. And Your Lordship, page 78.
Hmm? Page 77 is some order.
Some order, my lord.
Hmm.
We approached this honorable court, my lord. Page
Same, okay,
page-
same party,
My
right?
lord, same party.
Hmm.
Arunodaya construction, my lord. Readymade provision law. Mr. Day, learned counsel submits that whatever is required, the petitioner is paying the license fee in terms of the relevant circulars. But the respondent number 1 on misconception of the relevant provision law has issued further demand notice upon the petitioner to pay the arrear amount of fee as indicated above. By impugning demand notice that is on the petitioner having considered themselves not liable to pay any such land fee in the form of revised license fee has filed representation before the authority.
So where is this order, speaking order?
My lord, thereafter, my lord, clarification, this honorable court directed. My lord, we have then page 80, my lord, since the order was not complied, we wrote to, we have written to them.
Hmm.
And they have given reply to that, my lord. Thereafter, against that, we wrote to the authority, my lord, page 82. The amount which they are demanding 59 lakhs. Thereafter, we again approach this honorable court, my lord, page 84.
So out of court settlement, you said?
My lord, we have tried, my lord.
Then what happened?
Nothing has been happened, and they have written page 87.
Hmm.
They are ready to do page 87, my lord, kindly see.
87?
87.
Hmm.
Annexure 17.
Ah,
Please refer the railway board circular wherein it is clearly mentioned the licensing of ordinary commercial plots connected with the railway working as indicated in below will be done with the personal approval of general manager in consultation with so-and-so. The periodical review may so-and-so. Messrs. Arunodaya Constructions so-and-so set up the plant at Lamding after executing the land licensing agreement for a period so-and-so, so-and-so. Hence, in this case, renewal of land licensing is required as per railway board's above letter guidelines. Thereafter, it is therefore requested to initiate the renewal proposal to the divisional level and send the necessary recommendation duly vetted and approved by DRM for approval of the competent authority as per guidelines of railway
No,
board.
this is their internal letter. This is nothing to do with you.
My lord.
This is their internal letter.
So they process it, but my lord, nothing has been done as per the court's order. Then I approach this against my lord, same demand, my lord, 59 lakhs, 2009 demand. Against that, I again approach this honorable. The present matter is, my lord, in respect of the demand which was impugned in earlier litigation.
No, you are not Daya engineering. You are Arunodaya, right?
I am Arunodaya. Daya engineering judgment I have it.
Correct. So now this nothing was done in terms of this.
My lord. This honorable court directed accordingly nothing has been.
It was done in long time back.
Long time.
So nothing has been done till then.
In 15, they are saying they are doing it, but nothing has been done. Internal, although this is internal communication. Regarding renewal also, they are saying it is not that they have to take approval and then only renewal can be done. So what I am submitting, my lord, matter may be impugned, demand may be set aside, and matter may be remanded back to authority to assess as per the master circular. And they may also process for renewal of, my lord. In the additional affidavit, my lord, I have given a number of letters.
Why, what have you done after this order?
This next 133 is the calculation sheet, Lordship. It was
No,
done.
calculation sheet, forget about calculation, please. What have you done after the court's order? Any speaking order passed? There was a specific direction to pass a specific speaking order. See, the authority shall dispose of the matter passing a speaking order on the basis of the aforesaid, but why haven't you come with a contempt petition?
We have not come, my lord, but we come by way of writ petition again.
You should have come by contempt, but what writ is a different cause of action. Yes, madam, but this order is, this order was very specific. The authority shall dispose of the matter by passing speaking order on the basis of the aforesaid certification issued by the Chief General Manager NF Railway, and also taking into consideration the relevant facts, including any order, circular holding the field, and demand to pay an area rent shall be as per such decision. After passing the order, same shall be communicated. So you will have to take a decision what will be the rate, and that you have not done so, and you kept on demanding money from him. What is the reply in the affidavit about this?
They are showing nothing, man. Not saying. Yes, just saying.
Which is the paragraph
Para
in your writ petition wherein you have annexed this?
2, man.
This is annexer
12.
12.
Page 23, my lord, para 60.
That I have seen. Then where is the reply? Where is the affidavit?
My lord, affidavit. Para 12, my lord. Page 108.
108.
My lord.
Para 12.
Para 12, my lord. Nothing, man.
Yes, madam. What kind of affidavit is this? These are matters of record, so you need not reply anything, in spite of a court's order.
It's not explained, Lordship.
Nothing has been said. A court has passed an order to pass a speaking order, taking into account whatever circulars or rules were prevailing at that point of time. No order was passed, and he kept on asking money from them. You ask money, that you have, your land, you have a right to ask for the money, but that has to be done as per your.
Their prayer is to up to this 2010 only. In fact, Lordship, after that there was no such.
We are challenging 2009 impugn demand.
Yeah, 2009, 2010 demand in the same. In fact, this is the same demand notices. Thereafter, there was no demand notices.
But they have written letter in 2015 also. 15 also for a license agreement. That letter he has referred to just now.
But our case is that, Lordship, we have many times asked him to come, but no, he had not come forward, Lordship. And
but correct, we are appreciating that, but why have not you passed an order? You don't have any right to renew license. You have only right has been given to you to pass a speaking order, nothing else. And without passing any speaking order, you have written to them, come over and we'll renew the license. How can you do that? In violation of the court's order, can you do that? Can't do that. It could not have been done like that.
Impugn demand is at page 70, my lord. Page 7. (2009). Same demand.
But what is 11-2009?
Or initial this amount was there, my lord. Some amount what they did, it was adjusted, and this amount also, my lord, they adjusted it from my running bills. And this demand was challenged earlier, my lord. Justice H.N. Sharma order, my lord.
So there are 4 demand notices.
My lord.
11-9, okay, 11, then 12-1,
Then 19.6,
6-10-09 and 15-7.
19.6 later.
and you have approached the court earlier challenging which impugned order?
This, my lord, the pertinent impugn.
Huh?
Pertinent, same.
All these order, all these demand notices,
My lord.
all these 4 demand.
Same later was challenged before. This one, my lord, can we see?
6-10-201,
My-
6-10-209,
This is the letter,
2009.
same letter.
So you don't have a license agreement now as of now?
No, my lord. We'll renew, my lord. Once it is
In
settled.
that case, Lordship, paragraph from
18
paragraph 15 onwards of Daya engineering judgment. Finally, we look.
Because they are demanding it, my lord, as per present market rate, not as per circular. That's why it was not renewed.
Okay, we'll pass the order. We will interfere with this with you.
What is the finding of this Daya engineering,
No,
Lordship?
no, I have seen Daya Engineering. Daya Engineering, he says a licensing agreement has to be there, and you are in default. Why you have not entered license agreement? And if license agreement is not done, they should have been evicted by this time.
And they have to vacate.
And
They came
then
before
why
this
you have
honorable
not?
court, Lordship.
Don't you have estate officer?
Came before this honorable
Why
court,
don't
Lordship, and
why don't then
one
why didn't
after
you place,
another.
why didn't you place those things before this court that a state officer has already been instructed to vacate them? Have you taken any action from 2009? Madam, please don't give all these answers. You have not, I mean, only writing to them that will vacate you. You don't pay. And first of all, you have not complied with the order. You have not passed any speaking order. You have been asked specifically to pass a speaking order. You haven't done so. Then you have not renewed it. You have simply written to them, renewed the agreement. They have not come. You sat tight. You are allowing them to use this land, and you have, I mean, there, you are referring to there, so what coordinate bench has observed? What they say? See, I'll just read it for you. The land which have been allowed to be used by the petitioner is a land belonging to the respondent railways, which is a state within the meaning of Article 12 of the Constitution of India. And under such circumstances, when respondent in their own circular mandates that licensing agreement are a must before handing over a position, and in absence thereof strict action would be taken against the hearing official. What is this? Then why you have allowed them? Have you taken any action against your hearing officials? Now, how can you take 2 stands, madam? You cannot take 2 stands.
For the
So now thing is that, see, one plot of land, you said that there is no agreement. Then without agreement, first of all, you should not have given. So you are totally in default. Correct. You are totally in default, you shouldn't have. So that agreement, you'll have to get into a licensing agreement with him after giving him proper opportunity of hearing and like placing materials, and he'll have to take up the whatever, I mean, prevailing rates and all from the circle offices. That has to be given. Then agreement has to be entered into. And this other portion of land, which he has already been using, he said that he had a license agreement earlier. That has already expired. You'll have to get into a new agreement. And in terms of the new agreement, you'll have to fix the price. And as far as the areas are concerned, you will not get any areas because you have not done as per the law.
The page 121, Lordship, how to fix the land value. Page 121.
That's what I'm saying. I mean, whatever the prevailing, I mean, whatever has been stated in there, you'll have to follow that. You have to follow that. That's what I'm saying. Present market value, you'll have to see. Circle offices rates, you'll have to take. Surroundings, you'll have to see. Then you'll have to fix the market rate and you get into a license agreement with him. The other demand notices has to go. You can't do anything, madam. You are only appearing for the railways. Whatever is there. You can't do anything. Because the problem happened when you didn't pass any speaking order. You should have passed a speaking order. Anything else, Mr. Goyal?
So far as item number 3, my lord, I am, whatever your lordship is, my lord, I am ready to that. And so far as item number 2 matter, your lordship, they are disputing, my lord, challenging the territorial jurisdiction of this honorable court. Issue is same, territorial jurisdiction, my lord, on the ground that the impugned demand has been issued by NF Railway Katihar. My lord, NF Railway Katihar fall under jurisdiction of General Manager, Maligaon, Gauhati, number 1. Number 2, the original agreement was executed by General Manager, and in that agreement, it has been specifically mentioned, my lord, that I will show.
Okay, we'll take it up at 2 o'clock. I'll pass the order here.
Please, your lordship. Lordship, sorry to interrupt. Lordship, I beg to mention item 15, Lordship. I like to withdraw the instant case, Lordship. I'm for the petitioner. The parties have settled their disputes, Lordship, so I would like to withdraw. Item 15, Lordship.
Who is appearing for the other side?
Other side, Lordship, they have the knowledge actually. RC Saikia sir was appearing. So RC Saikia sir, Lordship.
Bring him. Otherwise, how can I mean, what is the document? You want to withdraw?
Yes, Lordship. The parties have settled their dispute. I'm for the petitioner, Lordship. So we want to withdraw the instant case, Lordship.
Okay, your name?
P. Chakraborty, Lordship.
Okay, right. MS P. Chakraborty, the learned counsel appearing for the petitioner, submits that she has instructions to withdraw the instant case as the parties have settled the matter outside the court. Prayer is allowed. The matter is dismissed on withdrawal. Yes. Yes, anything else on that?
No, ma'am.
Separate order in both the cases or Lordship?
We are passing separate orders.
Ma'am.
Because you are raising the issue of jurisdiction. That is the only issue, nothing else.
there, and where specifically stated that where the contract agreement, where the place work order has been allotted, that is the place where the dispute has to be settled. That is also in the contract.
Where is that? Where is that? Case number
Next one.
Writ petition number 2015.
2015.
Next one.
2015, there was an agreement.
Their lordship, no agreement was
No
there. It's
agreement.
only for the excess amount, excess land.
No, 2015, no, where is the arbitration clause you are saying? No, where, no, arbitration clause where?
There is no agreement.
There is no agreement, where is the arbitration clause?
In respect to other.
No. There is one.
Now, whether there is any agreement, lease agreement
No, my lord.
in 2015?
Lordship,
Only later of allotment letter was issued.
2702, 2703. Special condition of contract is there. No?
If there is no agreement, where is the contract?
Yes, sir.
Page?
It is in respect of 3.1. It is additional land. For this land, there is no agreement. In fact, in the impugned letter, you are saying.
Yes, but originally which land was there in agreement? Their clauses were there.
No. I mean, in this case, 2015, is there any agreement entered by you?
Demand notice for that, that there was no agreement. For which land we have this demand notice were given them. For their part, there was no agreement.
Then what is the point of having this thing?
Firstly, whatever they have taken, that for that there was an agreement.
Firstly?
Initial agreement, 1991. 1992.
But that's a different land.
Different one. It is additional land.
They taken those
Subsequently,
lands.
they have been given this
Yes.
land. This
There is no
allotment
agreement. They are saying for execute an agreement.
So there is no agreement there, correct?
There was no agreement.
So issue of arbitration clause will not arise.
Is there, lordship?
Issue of arbitration clause will not arise. You are raising the issue of jurisdiction, saying that it was issued from Katihar. And he is submitting that since Katihar is the Northeastern Frontier Railway, so Northeastern Frontier Railway comes, Katihar also comes under within this, and general manager sits in Gauhati.
Number two, my lord, the letter of allotment was issued by Maligaon, Gauhati.
Maligaon, Gauhati.
The petitioner is also the director of the company, also a resident of West Bengal. The work order was allotted from Katihar, Bihar, lordship.
Doesn't matter.
Jurisdiction.
You have given the allotment letter from here.
The case petitioner is in a specific state, or the at that time is serving in a specific place. The petition is filed in that case, lordship. In this case, lordship, the work order was allotted from the Katihar, and the petitioner is a resident of West Bengal. So neither a resident of this state also.
The allotment letter was given from here.
Page 260. Page 260, my lord.
But part jurisdiction arises?
Yes.
Bihar.
Part jurisdiction by page?
Page 260, 260.
Page 260.
260, my lord. My additional affidavit. Running page 260. My lord, Office of General Manager Works, Maligaon, Gauhati, to the petitioner's name, allotment of additional land.
Now, where page
260. It is different, my lord. Additional affidavit. Running page.
No, it says it's an affidavit in opposition.
My lord. Additional affidavit, my lord. No, additional affidavit. It was filed on July 2023. 24 July 23.
Additional affidavit filed on when?
On 24/7/2023.
26/7/2023.
202.
ये ना क्या अलग है
This one. Yeah.
कहाँ भाई इसमें कुछ
Yes.
क्या
Yes.
2006 पे
Later was issued on 13/6/2006. पेज नंबर में वेरी मालूम.
But lease agreement was executed in Maligaon.
But the demand notice is from Katihar.
Correct,
At that
but-
time, Lordship, at that time, it was done in the head offices. Subsequently, this is done in divisional office. That is why the
No, the agreement, lease agreement.
Lordship.
Lease agreement pertaining to which land?
That is different, original land. Thereafter, they allotted additional land.
Where is the allotment letter?
Allotment letter page 260. I think if your allotment page number may be different, that's why.
Now, your additional affidavit it starts from page 243 here.
243. 243, my lord. And my lord may kindly come to page 260. Or 261, maybe one page here and there.
260.
My lord. Office of General Manager. Office of General Manager Works, Maligaon, Gauhati. Later dated 13/6/2006. To the address to petition, allotment of additional land for increasing the length of siding of loading of 15 wagons at a time. You are requested, your request for allotment of additional land measuring so and so at Gauhati and being processed for approval.
And land is located where?
It is in there, my lord, in NJP. But it was done, it was processed at Gauhati and it was allotted by Gauhati Chief Track Engineer and a friend with Gauhati.
Demand notice is from Katihar only.
And
That-
demand
that is
notice
under
was issued
vigilance.
by my lord.
Divisional engineer
In
line
respect of
and
same land?
Katihar.
The
Page-
Katihar is between NF Railway, right?
NF Railway.
Unnoticed that is under
I
challenge.
understand.
Lordship.
But the corporate office or the main office of any headquarter is in Guwahati. Correct. And allotment has been done from Guwahati.
That
Maligaon.
Lordship head offices may be
But
here.
for the I mean land which is in dispute, that is allotted from Guwahati. So part jurisdiction, part of the cause of action arose here. Because allotment letter is the one whereby they got the land. Isn't it?
In
They got the land from where? From Guwahati, cause of action arose here. Isn't it? Or you are saying that demand notices were issued in from Katihar. But Katihar is within the zone of Guwahati. Katihar is not a different jurisdiction.
Head office is Gauhati.
NF Railway headquarters is in Guwahati.
Katihar is another state and petitioner is also from
State,
different
but
state.
railway has been, railway is not geographically divided. It has been divided region wise. So in particular region, I mean, the Northeast Frontier Railway is in Guwahati headquarters. Let's see what is what. I mean, you have raised this objection earlier, and what was the this thing interim in an initial order? What was stated?
Notice was issued and my lord, assurance was given not to deduct, my lord.
In the initial, it was stated, and so the honorable court directed to take it as a written in the affidavit. That to raise this question as a in the affidavit also, which we have raised, Lordship.
The affidavit, show me the affidavit, which page?
Carry on.
We have replied to that.
But in this case, madam, there is no agreement. How you have brought in this agreement?
It was in respect of my, no,
How this agreement was brought in? You are saying that the stand of the petitioner that initial contract agreement was signed by the general manager NF Railway Maligaon cannot be a ground to invoke jurisdiction. Whether they have taken this stand?
we have taken.
You have
Initial
taken this.
Original agreement.
No, correct. I mean, in this case, that original agreement doesn't matter.
No.
It doesn't have
That I am
any
not
role
pressing.
to play.
I am not pressing.
Here the thing is that now you are saying clause 2 of the subsequent contract agreement, but contract agreement is relating to something else, not for this land.
But the lordship, the first that land was allotted, thereafter in a continuation.
Have you signed any agreement for that? If you have signed any agreement for subsequent allotment, whether whether this plot of land is covered by any agreement? Whether this plot of land wherein the demand notices have been issued?
Mention of one agreement dated 14/8/09, lordship. In these paragraphs, we have mentioned one agreement of 14/8/09. As per that, clauses 2702 and 2703 we have reproduced, lordship.
No, I am asking one thing, that this subsequent agreement also, is it related to the particular land is in dispute?
126 to 216 of the writ petition, lordship. That 14/8/2019 agreement.
No, that is for which
Lordship.
land?
Let 126. एक second, देखने तो दे. यही उसी से था.
तो दिखाया कि काम सिलेंडर कर रहे हैं, डिमांड किसमें लिखा है एग्रीमेंट में?
Where is their agreement?
126.
126.
According to the petitioner, on the basis of this contract, they are different contracts. As per paragraph 4, lordship.
Madam, you are reading from here, reading from there. You are not able to give the court a particular things. When it is. No, you are reading from here and there. You are reading here now. You are not prepared. You are reading here, reading there, that you are giving something. Is this the way to do it? I am asking you whether this particular agreement is for this particular land or not.
Agreement.
I am asking you whether this particular land is covered under this agreement or not. You should answer that, no? You answer me whether this particular land, which for which demand notices were issued, whether that land is covered by this agreement or not.
But they are relying on this, the basis of this
Forget
agreement.
about they're relying. I'll ask them why they are relying this, but I am asking you a simple question, whether this land is covered under this agreement or not. If this land is not covered under this agreement, whether you can take any plea of this agreement. That they, again, you are saying that they are there. I am asking you whether you can legally take or not this plea. I'm not asking you about their stand. I'm asking you whether you can take this plea or not. If the land, particular land is not covered under this agreement, whether any conditions of this agreement will be binding on this land or not. That's what I'm asking. If land is not there in the agreement itself, whether that will be bound by this terms and conditions of this agreement.
When they are relying on this agreement and they
Again, you are saying so. I'm asking you whether, no, whether I'm saying, I'm asking you a simple question, whether it will be covered or not. You say covered or not covered, whether land is there or not.
land. That is not for this demand notice for which land we have given lordship. This
That is
this
the
contract
simple
not
question I'm asking you. To their reliance, I'll take care of this. Their reliance. I'm asking you the factual thing, whether it's covered or not. You'll have to give me a correct fact that this is covered, this is not covered. That's what I'm asking from last 10 minutes. Where is their reliance on this agreement?
Paragraph 4 of the writ petition.
You show me which paragraph they have relied on. They have relied on this agreement. As far as jurisdiction is concerned.
They are relying on the contract and there is the clause.
See, I am asking you a simple question. If you do not understand, then please ask me again what is my question. I am asking you, you show me from the petition that they have relied on this agreement for jurisdiction purpose. Is there any agreement? Is there any reliance on this agreement for jurisdiction purpose? You show me that. See, whatever they have written in these paragraphs, from my limited understanding from reading this, is that they are factually stating, they are stating the facts that there was an agreement. Agreement was entered upon this and this. Then after that agreement, they have been paying the license fee. Then thereafter, additional land was given to them. Then thereafter, they said that like this was suddenly these notices came, and notices came in, not in terms of the master circular. That is the facts they are setting. Where they have relied on this agreement for jurisdiction, you tell me that. You have been saying no, that they have relied on this agreement, relied on this, where?
They are relying on paragraph 4, Lordship.
Paragraph 4, what, you read paragraph 4.
Lordship, I have
You read paragraph 4.
There, Lordship.
Then what submission you are making? You are, see, they are saying that like there was a land allotment. Land allotment, there was no agreement. Land allotment was given from Maligaon. Now, in the facts, they are saying that there was an agreement earlier from the Maligaon. So they have to state the facts, isn't it? They're relying on that because they have to state the facts, what is there. But they are not saying that jurisdiction came only because of that.
The writ petition, after my filing of VTP, they submitted their reply stating that all those are from Maligaon Lordship. In the writ petition,
The writ petition also, wherein they have stated that because of this contract agreement, the jurisdiction falls under this. Is there any statement or pleading like that?
no pleading, Lordship, but
so you are saying that they have relied on, they'll have to give the facts. So they have given the facts. Is there any, I mean, you have made any statement?
No, man.
Stating that like jurisdiction,
No,
yeah, this court has jurisdiction because of the contract agreement signed.
What we have said that still we are working on that land, and for that they have given us contract also for manufacturing purpose. We are not saying that because of that I have annexed. In jurisdiction, I have given one decision, Kusum ignored, where the part of cause of action arose, dishonorable court. Para 9, 10, and 12.
Para?
First, you will also may kindly see
para, give me para.
Para 6. 6, 7, then 9, 10, and 12. May I read, Milo?
Yes.
So that fraction of cause of action. This is my submission.
Okay, we'll do one thing. Anything else, madam? Anything else to be submitted?
It is only for 0.80 acres of land, 292 page number. Here, in the previous case, there was one part is for license was there which existed. And here it is that they had acquired 1.26 acre of land. Subsequently, after our notice, they had vacated 0.46 and remaining 0.80 acre was their lordship. And here by this letter dated 13/1/23, we have asked them to to do the necessary thing after giving license fee and to execute the land license agreement, which was subsequent. Immediately they came before this High Court. So it's not that there was any violation of any order or that was not there. We asked them to
Second case.
submit license fee and to renew the license, but they came before this High Court for that additional
Because
plot
it
of
was
land.
not as per circular, that's why.
Hmm?
As per not master circular, this demand was. That's why, my lord, we came before this honorable court. Page 229, my lord.
Okay, I'll pass the orders. It will take some time, then other matters are there.
My lord.
Right, heard Mr. A. Goel, the learned counsel appearing for the petitioner, also heard Ms. B. Sharma, the learned standing counsel for learned CGC, right? Learned CGC for the respondents. Full stop. Hearing concluded, judgment and order reserved.
Deeply.
And then.
By order dated 26/2024, that is the LCR has been called for also.
LCR received? No. Not received. Technical errors, miss? Okay, not from the court side. Huh? Okay. Heard Mr. T. Das, the learned counsel appearing for the petitioner, also heard MS SS Hazarika, the learned APP for the state. TCR in the instant case is still awaited. Let the matter be listed when you are appearing.
But I am appearing as legal aid counsel on behalf of respondent number 2.
Okay, Mr. So-and-so, Mr. So-and-so, the legal aid counsel for respondent number 2. Let the matter be fixed on.
Court date may be 2018 matter.
30 May.
Stay order is there.
Let the matter be fixed on 30th of May will be too early probably. From where it is coming?
June.
Golaghat. But it was a long time, it was.
Yes, Lord.
First. Then you write register to send a reminder for procurement of the TCR in the instant case, full stop. Let the matter be fixed on
16th of June, my lord.
16th of June, yes, 16th of June.
Lordship, 16 I have some difficulties.
Okay, when then 18th?
18th. Oh, yes.
18th of June.
Interim order may be continued, Lord.
Interim order so passed earlier, shall continue till the next date of list.
Obliged.
Hearing also, your lordship. Notice was issued on
that?
8
Service completed and
Service completed 8/12/2021. Your lordship.
Tisha be
Madam.
called for also.
It is from South Salman of Malkachar, your lord.
So TCR not received again?
Yes.
Filing.
Wakalatnama?
No, objection, my lord.
Objections.
On behalf of respondent number 2.
Yes.
Then right, Mr. Majumdar is present for petitioner. Hazarika for MS Hazarika for APP for the state and Mr. R. Islam for respondent number 2. So you have filed or you will be filing?
Going to
Will be filing. Okay, TCR in the instant case is yet to be received. Let the matter be fixed on 16th June.
Interim will continue.
Interim
But
order,
it's there.
interim order so passed earlier shall continue till the next date of this.
Obliged.
My lord, here also on the last occasion, case diary was called for.
That is not there.
My lord, as per office note 11-5, my lord, this record is, my lord, awaited, my lord.
Okay, heard Mr. K. Singha.
Yes, ma'am.
K. Singha, the Lord Counsel for the petitioner, also heard Hazarika for Ms. Hazarika for PPAP for the state.
Lordship, the TCR has been called for, Lordship, but we haven't received the TCR yet.
You are appearing for whom?
Respondent number 2.
Your name? MS so-and-so for respondent number 2.
Bora.
Your name is what? Is B. Bora for respondent number 2.
My lord, interim is there, that.
TCR is still awaited. Interim orders of past earlier shall continue till the day, continue till the next date of listing. TCR code. TCR load करना है. It seems this one file has come TCR.
My lord, already that file is there. Now,
Studies.
yes, statement part is not there, ma'am. That's why that is called for.
That was called for again.
161
Yes,
statement is not there, ma'am.
Yes, yes. Okay. The register to send, it has been sent.
Yes, my lord. As per office note 11-5, my lord.
Okay, let the matter be listed after 2 weeks.
May I please, Your Honor? I'm for the petitioner. We have received a copy and Lordship we won't file the objection, but rather we'll go for direct hearing.
Your Lordship, the affidavit in opposition has been filed today. Perhaps it's not visible.
You are appearing for whom?
For respondent.
For the respondent. Heard MS so-and-so, the learned counsel appearing for the petitioner, also heard so-and-so, the learned counsel appearing for the respondent. And the learned counsel appearing for the respondent submits that she has already filed an objection in the instant case. However, the same is not on record. Let the matter be fixed after 2 weeks.
May I please, Your Lordship? This matter was already heard by Your Lordship from the
It-
side of the petitioner.
This was released.
Yes.
This was released.
To be heard afresh, or since the Lordship has already heard here only. So I can continue my part, Your Lordship, because stay is
Let the
there.
other side come. It was already released. None appeared for the petitioner when the matter was called for.
For this case today. They have talked to me, but why they remain absent, I
don't
cannot
know.
say. Because stay is there, Your Lordship, since long. And earlier also 482 petition has been filed. This is second. On the last occasion I have raised, and this judgment is with Your Lordship, I have already.
We'll put it up next week, after next week. Now, how can a stay be vacated just like that, madam? You're a senior counsel. Without the other party, I can just simply on your submission, I'll vacate the stay. What kind of submission you make, madam? It cannot be vacated just like that. We'll have to hear them out. Now no one is there. Then what is to be done?
Last one.
That's why I say it, like, I'll post it after a week or so. I mean, I'll because, huh?
Humble submission because of the.
It cannot be
stay,
vacated just
yes.
like that. A stay has been granted after, stay has been granted after due consideration, after hearing the parties. So without hearing the parties, how can the stay can be vacated just like that on your submission? It can't be done. So we'll put it up after a week. Let's see. I mean, nobody is there. What is to be done?
In the morning also. I don't
How
know
this
whether-
court knows now. None appeared for the petitioner when the matter was called for. Do M.S.M. Kumari, the learned special counsel for CBI is present. M.S. Kumari has shown some urgency in the matter. Let the matter be listed after a week.
After?
After a week. 1 week, after a week.
Made pleader. The matter is related to child marriage and along with the POCSO case, my lord. The petitioner, both petitioners are the husband and wife, my lord. The FIR lost.
This
by the
this call case that this case record hasn't come as yet.
Swapna? Yes, record. It 1035.
It's hard. MS H.M. Fukun, the learned counsel for the petitioners. Also heard
19.
MS S. Hajarika, the learned APP for the state. Case case record of special case number 18/2024, along with the case diary, is yet to be received. It is also seen that service in respect of respondent number 2 is yet to be received. Let the matter be listed after 3 weeks. After 3 weeks.
Takes my right.
After 3, then we'll put it on sometime in June. June 18th. Thursday, June 18th. Because this notice is also not served as yet. Take some time.
Oblige.
The service is complete here, madam. LCR received.
Is there received?
The madam, first date case. Trial is going on.
Yes.
Total custody is 5 months, 21 days, Your Lordship. 5 months, 21 days.
How much?
5 months, 21 days.
5 months, 21 days.
She may pray for another date, Your Lordship, next week.
No. What another date? Why?
Also.
Before that, I am also submitting, madam, the regarding it's a POCSO case, madam. Perhaps.
That's why I'm saying for the another date is not required. We'll engage someone, appoint someone.
Yes.
Because service is complete.
Lordship, service.
Otherwise, madam, there are sufficient materials against the petitioner.
1 second. Service is complete or not?
Service complete, madam. I have the report, madam.
You have the report. When it was up?
It's way back, madam. 6.
14/6?
No.
14/6 what?
It was made, madam.
14/6, how can it be 14/6?
Yes, madam, because.
Notice was issued on 19/3/2026.
Oh, madam, it's a FIR date, madam. Sorry, madam. FIR date. 2/4, madam.
2/4. So we'll wait for another date then. Somebody might come, turn up. Heard Mr. A.R. Karim, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. The learned APP submits that service of notice upon respondent number 2 is completed. Full stop. However, no one appeared for respondent number 2. Let the matter be listed after.
May kindly, Lordship, on 25 or 26, Your Lordship.
Let the matter be listed on
25. Today's 19, Your Lordship. 25 May.
25 days. Which day?
26 hearing day.
Okay, 25th.
Lordship.
25th.
Oblige, Lordship.
25.
MP Kiswami.
नाम तो बोल रहे MP
Please, your lordship.
I also, my lord, perhaps my lord, same order has to pass, my lord, service report complete, my lord. It is in the month of April, my lord.
Okay, the same order you pass and write his name, Mr. D. Bora. And fix the date on same date.
Lordship is appointing amicus, my lord.
Huh?
Lordship is appointing amicus curiae, my lord.
Who? Next date we'll see, because it was served only recently, not, let us give some time.
Well. Objection.
It is the lordship. My 483 application.
These are all bail hearings, no? Mr. Boda, I think we can give some earlier date. These are bail petitions. Both the matters, huh? Give some earlier
The
date.
third occasion, that's why.
Kareem also, you just intimate him.
Can be on 26th, my lord.
Give it on 26th of May. You just intimate Mr.
I'll inform
Kareem also. 26th of May.
It is the lordship. My lord, in this case, the petitioner is in custody since 2/9/2024, my lord. 2/9/2024, my lord.
2/9/2024.
2024. And my lord, the grounds which he is before your lordship are twofold, my lord. One, my lord, first section 35 notice, 47 notice, my lord, which is page 35. There is no such ground, my lord. Only an intimation was given to him.
In
47, my lord. The notice which has been issued under section 47 of BNSS, my lord. Only an intimation, it contains an intimation.
What is that notice?
It is page 35, my lord.
You are earlier rejected for what?
Yeah, my lord, the lordship order is there.
Where is that order?
Yes, it is, my lord. It is.
It's 31.
Page, lordship annexer 4, page 28. The submission was of prolonged incarceration.
Where is the notice?
Notice page 35, lordship, I kindly help, madam. Lordship has got it, lordship.
Yes.
Page 35. So may I just, lordship, request lordship to peruse page 36, which is annexer, my lord, 7. The arrest memo which has been issued under 36 of the BNSS. There lordship will find only, my lord, his signature of the arrest is there, but there is no such signature of the, my lord, either of his family member or a respectable person of the family, my lord, or a respectable person from the locality where arrest has been made. So this is another violation, my lord.
What was the offense?
My lord,
NDPS. How
yes.
much quantity?
It's 102 kgs of, my lord, ganja, my lord.
The quantity also.
Paragraph 3 of my petition, I have, my lord, described there. And TCR has also been received, my lord, in this case.
And you were there for
2/9, my lords.
2/9.
2024. Today is, my lord, 1 year, 8 months, 17 days.
1 year?
8 months, 17 days, my lord. It comes to
And
624
what is the
days.
stage of this thing?
My lord, it is fixed for evidence. Charges was framed on 15/5/2025, and till, my lord, till date, my lord, witnesses has not turned up.
Till now, no witness.
Yes, my lord, as per the records, my lord.
15/5?
15/5/24. Charges were framed.
Yes.
For the status, present status report of the.
Up to date report is. My lord, it is that.
And
Maybe when up-to-date status will be regarding examination of witnesses. Maybe 1 or 2, 3.
No, my lord,
That will not
my lord, the
matter.
record is very much up to date. Their entire order sheets are there, my lords.
shell quantity.
But you have not complied with 47 notice, 36 you have not complied with.
Yes, ma'am.
What is to be
Lordship,
done?
so far as 47 is concerned, so this is relating to communication of grounds of arrest to the,
No,
that
no,
is the
the
mandate.
court is, Supreme Court is very clear. You'll have to give a written notice with the grounds, very clear. So if the grounds are not there, it's not about communication, prejudice, those concepts is gone. So if you do not give prior to his, this thing, production before the court, prior to 2 hours, that has been laid down Mihir Shah's case only.
Yes, ma'am.
So you'll have to give, so without that, like that, there is no compliance. And these are statutory provisions. Section 62 of BNSS says that any arrest you make, it has to be in terms of the statute. And if there is any statutory violations, then that whole arrest becomes illegal. The whole arrest becomes illegal means what? He gets a right to get bail.
Otherwise, Lordship, so far as my only contention is this, he was arrested on Lordship 2/9/2024. And as per Mihir Ranjan Sas versus State of Maharashtra, that the Supreme Court says, Lordship, I'm just reading the relevant pages.
No, you just tell me what is that.
It has been delivered on 6/11/2025.
No, you tell me, madam, one thing. Only one thing you tell me, that is there any distinction in this case? It can be distinguished from Mihir's ratio.
I'm just coming to the relevant paragraph. Lordship.
Yes.
Kindly come to page 34 of the petition.
No, you just read what is there.
In Mihir Rajesh versus State of Maharashtra, the Honorable Supreme Court has observed that we are cognizing that there existed no consistent or binding requirement mandating written communication of the grounds of arrest for all offences. Holding as above would ensure effective implementation of the constitutional rights under Article 22 of the Constitution of India. Such clarity would avoid uncertainty in the administration of criminal justice. The ends of fairness and legal discipline therefore demand that this procedure, as affirmed above, self-govern arrest henceforth. The use of expression henceforth clearly indicates that the requirement of compulsory written communication of the grounds of arrest has been made prospective in operation. So, and the judgment was given on 6/11/2023, whereas the accused was arrested on 3/9/2024. Even otherwise, the records reveal that a notice under section 47 of the BNSS was issued and no prejudice has been caused to the accused. Lordship, considering the nature of allegations involving commercial quantity of contraband, statutory embargo of section 37 will come into play. And the records also says there is no such demonstration prejudice has caused to the petitioner. Lordship, the record says.
Then come to the ratio of the Mihir. That last paragraph.
Lordship, that I have read.
No, not that one.
But I have the copy. Lordship.
Just give me the copy.
Request, my lord. I'm just sending over a minute. Extra task अपने लोगों को.
Para 54 or something like that. 54.
Para 50. I'm reading paragraph 58.
Not 58.
It starts from 54, my lord, the directions. 54.
54 says, may I read, Lordship?
This is here. This paras will be different. Na? I mean, you have taken it from
the Supreme Court website, my lord. Lordship is looking for this directions, my lord.
Which para is this?
Somebody directions.
In SSC, it's para 54 or something like that.
Here it is 58. I have.
My lord, the conclusion starts from paragraph 56. Paragraph 56, my lord, conclusion part.
Yes.
And you read para 54, 58 you have written, right? Yes, it says henceforth.
Yes, Lordship. May I just submit one thing? That aspect of
Your case was prior to this.
yes, exactly, madam. This aspect of 2 hours was clarified in the Mihi Rajesh. Prior to that, in Prabir Purkast or Vihan Kumar, there was no fixed time within which a person has to.
Correct. So that's why this Mihisa has clarified it, that it will be henceforth.
By the 2 hours part was clarified.
No,
At
2
least-
hours is.
At least 2 hours window has to be there.
We are not in the time.
Yes.
We are on the application of this ratio of this judgment. Now, a ratio of the judgment says that the ends of fairness in legal discipline therefore demand that this procedure as affirmed above. The procedure means before 2 hours,
Yes, madam.
production, this and that. So, as affirmed above shall govern arrest henceforth. Henceforth means from now onwards.
Now onward, madam.
So your arrest was earlier.
Madam-
Your arrest, that's a specific time period or whatever guidelines have been laid down, that will not be applicable.
That has already been clarified in Prabir Purkast, my lord. May I just have it?
Probable Purkasta has been discussed in this case.
Exactly, my lord.
That after discussion, they have come to they have stated that there is no consistent view.
Yes.
They have come to this observation also, that the statute also doesn't give any timeline. Now, in view of that, they have discussed all these cases. After discussing all these cases, that they said, yes, the written notice, section 50 has to be given. But now they are saying that this has to be, but henceforth it has to be given.
So-
That means prior to that, if somebody is arrested, if not given, that will not, it will not be covered.
My lord, in my humble understanding, that will be interfering with the fundamental rights, my lord. And that has already been, my lord, in
It
Bidhan
has
Kumar.
been stated by Supreme Court, fundamental rights, all these
That is
things have been,
subject to correction.
all these things have been discussed.
If lordship, there is another recent order of division bench, my lord.
Mr. Chaudhary, can you help us? The senior counsel is there, we'll take his help. Mihir Rajesh Shah. Now Mihir Rajesh Shah, please have a look at page 50, para 58.
In conclusion. In all offenses, I have this thing. As per IPC.
You should make consistent with ensure organization personal rights provided to such clarity on the obligation would avoid uncertainty. The ends of fairness and the legal discipline therefore demanded this procedure as a power. Henceforth.
That is not 47.
So it has put henceforth.
Henceforth, from the day when this order was passed.
So that means, if some arrest is made by prior
You
to.
not know the subject matter of this side.
No. We are not talking on the merit.
But it says matter
Henceforth.
henceforth.
So henceforth means that after passing of this order.
Not, it is a perspective.
Yes, prospective.
Perspective.
So it is not retrospective.
Not retrospective. So far this says matter there is some discrimination there. Some court says this thing, some other court this thing. So court says henceforth you have to follow this thing.
36 is also there, sir.
No, 36 is
36 is violated. It is there, sir.
No, violation will be, in that case, it will not be prospective matter. That is constitutional matter. But here, so far, this is not.
Notice is to be given, that is correct.
Yes, that you have to follow.
But you have to follow, but the arrest which has already happened. Now,
Already
prospective arrest, you'll have to follow this.
No, all things not, my lord. The ends of fairness and the legal discipline therefore demand that this procedure as affirmed above shall govern arrests henceforth. Affirmed above.
So that 2 hours prior to that notice has to be given. This given.
Here, only thing is, my lord, that in conclusion, it is held that paragraph 56, the constitutional mandate of informing the arrestee. The grounds of arrest is mandatory in all the offences under all the statutes, including offence under IPC. The grounds of arrest must be communicated in writing to the arrestee. Then the arrestee officer is so and so. After having come to the above conclusion, it is pertinent to note that the provision of law under section 50, that is 47, does not provide for a specific mode of or time for communication towards arrestee to the person. So that is, I think, about the mode of the communication.
Yeah, mode of communication and time frame.
And time.
Mode of or time frame.
Yes, mode of communication or time frame for communication of the grounds of arrest to the person arrested. Only on this point, by the henceforth, it will come.
This court in Prohibitions hold that
Prohibitions held that the grounds of arrest be conveyed
to
the arrestee in writing in all the offences at the earliest, which means it need not be given at the time of arrest. Earliest means not necessarily mean that at the time of arrest to give arrest, but within a reasonable time. Therefore, for offences under all statutes, which period has been laid down above in this order.
That 2 hours.
Huh?
2 hours.
2 hours. In other cases, man. So we are cognizant. So far, this thing is concerned, madam.
So maybe, madam, only for the mode
More.
and time of.
Only that thing.
Not for the grounds. The grounds have already been seen in Prabir Bansal case also, that was
Yes.
what that was discussed. Purkast also that was discussed.
Yes.
Yes.
Grounds has to be given.
Yes.
But now the
How?
Mihir Supreme Court has said that as far as this timing of this grounds of arrest, that has to be prior to 2 hours of his production
Lordship,
and a written notice.
to again come to paragraph 58.
No, we have read it 58 many times.
It take to be read with 50 earlier one.
Lordship,
You can't read one in isolation. No?
Yes. I also earlier come to madam, oh, this come, it's a modern time. Yes.
Lordship, then 56, paragraph 56 will also be relevant.
Yes, yes.
No, see, I mean, otherwise, the ratio laid down in Prabir Purkayastha, then this Pranab Bansal's case, Rihan Kumar, everywhere it has said the grounds have to be given. There is no doubt about that. And from those time, these cases have been handled, correct? And there are, I mean, where grounds were not given, bails have been granted because it was found illegal. Now, why Supreme Court is going to disturb that position? Supreme Court has discussed all these cases, and that position Supreme Court is not going to disturb. Only thing they are saying that the mode of communication and the time. They are saying here they have specifically laid down the 2 hours prior to the production. You'll have to. And in the language that is understood by the arrestee.
Whatever may be, Lordship, he was arrested on 3/9/2024. Date of judgment is of Mihir Ranjan sir, that is 6/11.
Correct. So now his case is that he has not been grounds only. He's not saying about it has not been given to be.
Sitting there.
Yes. Thank you. Thank you for your support. So, so that is the issue. So that is the only ground, right? You have.
Yes, but 36 is also absent, my lord. The requirements of 36. Their lordship will find no witness of any family member or any respectable person, my lord.
But you have been section 58, not 48 notice have been given to you?
No, my lord.
Huh?
That is also not there.
48 notice is not there.
No, my lord. 48 notice is not there.
Okay, we'll post it sometime in the next week.
My lord.
Let us go through this, then we'll pass an order.
My lord.
You also go through this. Let us see what is, I mean, if there is something you can bring in. Okay. Let the on the joint prayer of the parties, let the matter be listed on next Tuesday. Next Tuesday, 26th.
26. My lord, can it be on 27? Next week I have some medical 27, my lord, if possible.
27 is a missing. 28.
28, my lord, perhaps Eid will be there because earlier it was 27, but now we are not hearing that it will be on 28th, my lord. So next day, if possible, my lord.
First week of June, Lordship.
29, my lord, kindly, my lord.
Let us have it on then this thing, 4th of June.
What, my lord?
4th of June. 4th of June. Yes,
My lord, second time, only 30 question of 36, my lord.
36.
Idea it could not be brought, my lord, because we did not have knowledge, my lord.
See, 36.
Only burden of 36, my lord, your lord.
36 arrest memo, right?
Yes,
See, there is a question there. I mean,
page 41, my lord.
there was another case which came up before me, before this court.
Yes.
And let us see, it's 36.
Yes, that page 40.
See, in this case, 47, 48 has been given, right?
Yes, that's fine.
Only 36.
Only 36.
So 36 has
And I have given your lordship's order also, my lord. 36 and
yes.
48 different, my lord.
Huh?
Though somebody says, my lord, that if 48 complies, 36 is not required. But your lordship held that no, 36 is different thing because 62 is there. So it cannot be. Your lordship judgment, we have annexed also, my lord.
Incorrect. But that is correct. I mean, okay, which is this order?
Yes. Your lordship's order.
Yes.
No, that is only my normal.
No, in that case, whether 47 was discussed. No,
It was discussed.
we did not, my lord. That is your lordship's order is, earlier order is,
711,
48, page 48,
page 39.
page 39.
Hmm?
Your lordship order is page 39.
Page 39.
40, your lordship.
Yes. No, that is not the order.
Huh?
Election order, RDF.
Page 48 most probably, you see.
Yes. Page 48. Oh, yeah, yes. Now, it is similar order.
Huh?
48 is similar order, my lord, in my
Yes,
case.
48, whether we have discussed 48.
No.
No,
In
that-
four,
it was
page
not
number
discussed.
40, idea rejected.
No, correct. So 48.
No, nothing.
No discussion is 48.
No discussion.
So there was no plea about
No,
48.
they also there.
Now thing is that in 36,
Yes.
you also assist us. I mean, you also take our BNSS.
Yes, we have. 36. Page 36 wasn't. Section 36 noticed one page. Yes.
Page
আমাদের যে sign নাই না signature নাই.
See, if there is 48 violation and 36, there is no signature from the family members. Absolutely, there is a violation. But if 48 is complied with, then whether 36, if there is no signature, whether you will have a ground or not.
My lord, in my humble submission.
Please read, please read.
Yes.
Please read
36.
from
Every
36B.
police officer,
Hmm.
while making an arrest shall. May I say idea prior to my reading, my lord? 36, it is concept is begun at the time of arrest.
Correct.
What you were to do.
Correct.
48 comes after arrest. My lord.
Correct.
So that's why my lord, keeping that in view. We should,
You see, for 36 has come because of DK Basu, right?
yeah, and this.
This concept has come from there. A
Yes.
concept and object was
Yes.
a person, and I mean, object was totally different. Object was somebody, maybe a political figure, and there is some, some kind of, vengeance or whatever.
Sometime, yes,
Somebody is arrested without telling anybody where he has gone.
Yes.
He has been taken away. So in those kind of situations, to protect a person, 36 was brought in. Correct. That was the object, and this thing of DK Basu also says so. Now that has been made a statutory provision.
Yes, now
by 36.
Yes.
Now the object was little bit different than other usual cases.
Certainly, my lord, legislative intent.
It was not for this because
legislative intent my lord,
was different.
different.
What different? Because those habeas corpus cases, this and that.
Right.
So now 36 has brought in.
Let us see.
Let us see 36.
Every police officer while making an arrest, your lordship, while making an arrest shall bear an accurate, visible and clear identification of his name, which will facilitate easy identification. That prepare a memorandum of arrest which shall be, your lordship, which shall be attested by at least one witness,
Yes.
who is a member of the family of the person arrested, or a respectable member of that locality where the arrest is made.
Correct.
Sometimes arrest made by another district.
The family member will not be there.
No, not with so particular person of that particular area. Respectable.
Correct.
The countersigned by the person arrested.
Correct.
Inform the person
Now,
arrested.
To see
Yes.
is important thing.
Now see. Inform the person arrested. Unless the memorandum is attested by a family member of his family that he has a right to have a relative or a friend or other any person named by him to be informed of his arrest. Now,
So now, if your family member has not given any signature in the arrest memo, but he has given a notice of section 48, then it is complied with.
now if your lost letter, if we read 48, my lord.
Very correct.
Well, whole question timing, my lord. At the time of arrest,
Yes.
while making arrest.
No, correct.
This is the language.
That is very important fact. I mean, we appreciate that.
Right.
I mean, that has to be given same time. It
Right.
cannot be that like arrest has been made yesterday
Yesterday.
and you are intimating him
Right, man.
after 2 days.
Right.
That cannot be done. But if it is at the same time, then if 36, the signature is not there, then there is a provision that you intimate
Yes.
by section 48 notice. If 48 is complied with, then there is no violation of section 36.
Now let us
That is how I read it.
Well, let us come to 48, my lord.
Yeah, 48, yes. 48. Yes. Every police officer or other, your lordship, what it meant?
Yes, yes.
Every officer, police officer or other officer making any arrest under this Sanhita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other person as may be disclosed or nominated by the arrested person for the purpose of giving such information, and also to the designated police officer in this district. The police officer shall inform arrested person of his right under subsection 1 as soon as he is brought to the police station. An entry of the fact has to be as to who has been informed of the arrest of such person shall be made in a book to be kept in the police station. A GD entry, that is, in such in the state government may rules provide. It shall be the duty of the magistrate before whom such an arrested person is produced to satisfy himself that the requirement of subsection 2 and subsection 3 have been complied with in respect of such arrested person.
So here it's forthwith.
Forthwith.
It's forthwith. So if it is forthwith, if somebody gives a notice after maybe like 1 day or 2 days, then 36, if he says no, 36, 36, there is no signature, that is correct. But we have already given you a notice. That cannot be correct proposition. But if at the same time, arrest memo doesn't have a signature of the family member, but at the same time, while arresting him, a family member was present and he has already been given a notice under section 48. And in the opinion of this court, that is section 36 violation cannot be said.
If that is there, if anyone was present
If family member has been given at the same time.
at the same time, same time means, my lord, whether it is given at
It has to be.
we may see the timing, my lord, when it was given.
When
136.
No, that we'll see. No, we are talking about this
No.
law
No,
thing.
that's,
no.
that, my lord, that is the matter of interpretation.
No, we are just discussing.
the question
No,
is-
we are just discussing.
Yes, yes.
Aru, we want your
Not
assistance
much.
as well.
You-
It's not about your bail case.
No.
We
I'm
are
not on this case.
we are discussing
Yes,
because
ma'am.
we
I'm
want.
not in my case.
No, we want your assistance
My
so
lord,
that like we can.
only what I understand, my lord, because the legislature, when they have, my lord, legislated on this point, 36 they have there, 47 is there, 48 is there. One section would, my lord, would do. One section, 36, or 48 was not necessary. If 48 is there, 36 was necessary. So there must be some purpose of enactment of this particular incorporation. So that's how it is. Now, so far 36 concerned, leave aside my case, madam. 36, what it says, transparency, basically. As your lordship mentioned, sometimes they do it.
Yes, transparency.
Yesterday arrested, 2 days after them, they saw that he's arrested. And it is now it happens. We also find sometime, madam. So the question is here, the so far 36 is concerned, whether this arrest transparent or not.
No.
That is there, and for that, signature of the family members or any other person of the arrest made of particular area.
At least they are aware that
They should
this person
be
is been
aware that,
arrested.
yes, your man has been arrested. So that was only by the immediately family member may not be available. That's why permission was given from that area where he has been arrested.
Correct.
That's why that occurred. So they have to be informed. They have to get information immediately. This
Because
is
the-
the
because the-
innuendo of that human.
Correct, because family member may not be there.
One of the innuendo, what I am saying in that is the innuendo of that, my lord.
Correct.
The basic intention that. Now, that is 24 hours, Article 22. Article 22 comes here, my lord. So only in order to Article 22, time is given. When one is to be produced. Only, my lord, is that is transmission or
Yeah, that transport time, that is only
transportation,
time.
that is otherwise Article 22 is to be followed.
Immediately he should be produced.
Immediately he will be produced, accept. So that is. So my question, the legislature might have intention, certain number of 36 is one intention, 48 is different intention. 48 is one after the arrest. At the time of arrest. That's what I meant to say, your lordship is to say. At the arrest, what you have to do. After arrest, what you have to do. In my humble submission, 48 is after arrest. And 36 is at the time of arrest, only to make it a transparency and that is.
No, you are correct. You're very correct.
So.
You are very correct. Only thing is that
Yes.
in a situation, if the family member's signature is not taken,
Right.
not the family member was present, but in spite of that, family member's signature was not taken by arrest memo. But at the same time, while arrest was made, a notice of 48 was given. Then the purpose of 36 is complete.
48 notice is not why arrest. Notice is the reason for the arrest.
No, correct.
Why?
Reason for the
Why he has been arrested.
reason for the arrest means that like the intimation has been given.
48 says only why he has been arrested.
No, 48.
And for 36 says he has been arrested.
Correct.
That is the only information.
Now 48 also says that like intimation about his arrest and the grounds.
Ground, basically grounds, man.
No, but intimation also that he has been arrested. Otherwise, if he is now, I mean, the intimation as well as the grounds.
It kuntu disa.
Sir, 36 or duta part is.
The 48 to 80.
Regarding such arrest and place.
Just my lord.
48.
That. Because there is some 48 to laws on that is.
It's a two part.
Lordship, subject to correction, so far as 48 is concerned,
Kunta
only
part.
the ground of arrest is not required, only the information has to be given to.
No,
the
but
witnesses.
the case is clarified. Vihan Kumar has clarified. Grounds has to be.
36 is two part, my lord. Your worship can be.
Yes, I have 36.
36. Now, first is, my lord, every police officer when in arrest shall bear an accurate, visible, and clear identification of his name, which will facilitate easy identification. It is one part. Second part is, my lord, after arrest, prepare a memorandum of arrest which shall be attested. At least one witness who is member of the family of the person or a person that countersigned by the person arrested. Then it comes C. Thereafter is to inform the person arrested.
It says and, it's not or.
It
says and. And inform the person.
Inform the person arrested. Unless the memorandum is attested by a member of his family. So if it is not attested, then they have to inform.
Correct.
One family member attest, there is no
Then
question.
no question.
Yes. That he has a right to have a relative friend or so and so and so and so and so to be informed. So here, my lord, only what I meant to say is attested by at least one witness who is a member immediately to inform the person concerned and family members to take the appropriate action out of the.
Correct.
Now 48 says, 48. Every police officer or the other person making any arrest under this Samhita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other person as may be disclosed, nominated information as to the designated police officer in the district. The police officer shall inform the arrested person of his rights under subsection 1 as soon as he is brought to the police station. There is rights, etc. You have right to move, etc.
But these two are statutory obligations, right?
Yes.
Two are statutory obligations.
Yes.
Now, only thing is
the
that
questioning one, it is statutory, it is very clear. It needs no interpretation. Interpretation when comes, when is unambiguous. If it is unambiguous, there is no question of interpretation. So here, so 36 concerned, these things you have to do. 62 says, if it is there, you must have to follow. 62 says. And 48, my lord, in my humble submission, it comes later on, my lord. Not, it is, my lord, that at the same time. I also understand what your lordship is of mind, your lordship, my lord. Once informed, that is sufficient. I also understand, my lord. But why statutory made two distraction, my lord?
the statutory object is
So there is nothing different, my lord. Otherwise, the statute enactment would not have been done, my lord, for why two sections to be given.
Correct. Now, they have a right.
So when we interpret the legislative intention, my lord, that we have to say from the debate, constitutional debate or what is, only we can get the, my lord, what was the intention of that. From the debate, we can get it, my lord.
Correct.
Assembly debate or parliament debate, that we can get it from there.
No, this object.
Otherwise, what I mean, say, different, my lord. From object is different. That is in
Object is different, and whether object is complied or not.
Complied or not.
But other thing, you are very correct in saying the statute has given certain things, and it has to be followed. It has to be followed strictly.
Strictly.
If there is 62 is there, so if there is no there is some violation, then it
Yes.
gives you an unfettered right.
Mm.
That is there.
Mm.
But only thing is that, I
And
mean,
your lordship interpreted in that way also, many judgment, your lordship orders are there.
I have, no, because those cases,
Yes, yes.
48 was not raised. 48 was not raised, and 40 was, whether 40 weight was given at that point of time or not given at that point of time, it was not raised. But there was one case, in fact, like while I was sitting in Arunachal Pradesh, a case came like this, that there I have seen the case records. In that case, at the same time, when the person was arrested, his wife was also there. So his wife was
In that case,
intimated,
I think, my lord.
47 was given.
In that case,
But still, I did not dispose of the case. I have asked that there was a young guy who was appearing in the matter. I asked him, "Can you come up with your things?"
That, in my opinion, I think if wife is there present, I think, my lord, that
So
in that case, 36,
sickness,
48 will do.
that is what I just wanted to.
If she is present.
Some
Certainly.
assistance.
But here, some cases are there where family members are not there. But, local people are also not there. Not there.
In that case, there is no, I mean, there is no
Yes.
issue. I mean, if family person is not there, you have not taken any signature of the witness, then there is a sheer violation. Sheer violation. No doubt about
Your
it.
lordship correct one. This interpretation, I think, in that case, my lord, 48 will do. If wife is there, or any of the family member.
Any family member is
or
there,
relative is there at the time of arrest.
then the purpose and
Purpose
object
is, sir.
36.
Intention is by the family member got or not.
Correct. So that is,
So that is
legislative intention is that. Intention
That
is
was
there.
correct.
That is
this
what I was just little bit
Yes.
this thing.
But
But your case is
objective is to, what is the object? To inform the family member.
family member.
You are present now.
So they are
36.
aware and they know about the variables.
That purpose is, sir.
Correct. So okay, we'll think about this. And in your case, what is the situation?
In my case, my lord, only I have come 36, your lordship, kindly say 36 page, page 43, your lordship, kindly say. Two petitioners, my lord. One is 43, another is 45. Only on the signature also, signature is nahi naki. Signature ko to nahi. Accused of.
So arrest memo is not complete.
Page 43.
Yes, arrest memo is not complete.
Yes. 36. That is 36 by us, huh?
Yes, 36 arrest memo. Arrest memo is not complete.
Yeah.
Now let us, have you annexed this 47, 48, nothing?
Yes. No, 44 I have
So,
not. It is maybe in the
47, let us see 48. And when it was complained?
date. It would date nine. It would date.
At the time of arrest.
No, it would date. No.
1 p.m.
Oh, you were date.
1 p.m.
1 p.m. What's supposed to?
Taken time of arrest 1 p.m. Point number 5.
Ganesha হবে Ganesha হবে
More or less. So 52 percent.
না এইটার মধ্যে ইস্যু আছে কবে আছে কত জীবন কত আছে এটা 30 শুধু ডেটটা হবে ইস্যু আছে ওটাও তো হয়ে যাবে এটা তো
All at 1 p.m.
One arrest date of time there, they are stated date and time of arrest,
Yes, 1 p.m.
1 p.m.
1520.
1525 at 1.
At the time of arrest.
At the time.
That is the time of arrest.
Yes.
But notice your loss kindly see.
No, notice only, notice also, in notice it has been written.
Notice and the date is not, so far this 36 is concerned.
No, 36 is also, there is there, time is there.
Time is there,
Time is there 1 p.m.
1 p.m. That is,
And in the 47 also it's 1 p.m.
yes.
and 48 also 1 p.m.
No, that is not in dispute, my brother. 1 p.m.
So at the
arrest-
same time that has been given. So, I mean, when arrest was made,
Yes,
the section 47 notice as well as 48 notice were served. 47 notice to the person accused and the 48 to the person who is nominated.
so 30, so far I am on 36, but I am 47.
Correct. So,
30 your lordship is in 36.
yes, 36 there is there.
Whether any
The
signature.
30
and
signature
counter
is
sign,
not, signature is not there.
nothing there.
Signature is not there. That is correct.
Yes.
So there, it is not in terms of 36. The only thing is that because of 48 notice, whether 36 can be said to be complied or not. Now that interpretation will have to.
That whether any family members were there or not.
That is the only, as per this, they were there. They,
Family members.
family, one of the family member who has been nominated by him, he was
But
there.
no, because police station some stock witnesses are there, madam. Your lordship.
And as per the record, I'll have
Anyway,
to.
so far I am concerned, what I am saying, it was not given my.
Correct. So as per the, I mean, case records, what has come that I have checked also, properly checked, because same time, same date, 47, 48 notices were given. In the other case I was referring to, in the same, that case also same thing happened.
Yeah.
The wife was there, wife was given. But his only argument was that, no, section 37 was not complied with, not that. He was a young fellow, then I asked him, "Kila, you just read and come back." I fixed another date for that. And Mr. Chaudhary fortunately came to our court, so we took his assistance.
No, that my lord, I am obliged to your lordship, that is.
No, so not, this is not only for this particular case. It has,
Yes,
something has to be,
yes,
something
we
has
should
to
not
be.
We should not confine ourselves.
Yes, something,
should have-
if there is some
Yes, yes, yes.
ambiguities, we should.
If we are losing, we are winning, my lord, that is another.
No, I really, I know about this, that's why I'm asked you.
That's-
Because this has to be clarified, otherwise there is some
Exactly, sir.
confusion
It
going
is
on.
our duty to see, my lord.
Correct. Confusion
That
going
is, whether I lose or win, that is not a matter.
But you are assisting the court in settling something. Settling means, I'm not settling anything, but only thing is that if there is some ambiguity, some confusion is going on, then we can
So-
say something. on
So
this.
only in this case, my lord, one thing can you do, my lord? Let me have some information.
Hmm.
Whether my lord, she was there, anybody was there. or
It
not.
is there in the case record.
No, my lord, so far 36
No,
concerned.
36, no, 36,
Well, 36.
36 is incomplete.
Now, 48, whether my lord.
36 is not, no signature has been
Whose
taken.
signature, my lord?
30
One way to see, my lord, whose signature, that do you,
36, there is, okay, I'll tell you the name.
yes, ma'am.
I can tell you that that's not a problem.
We may have a copy, my lord, I think there is no bar, my lord.
No, there is no problem in giving you the name who has signed it.
Yes, those and one देखो. ये तो लिख लो ना. Kobo.
That name has been given by the arrestee, lordship. That name has been given by the arrestee.
Now let us see who has been given.
What else is required, lordship?
The name of the accused is Zahirul Islam, right?
Yes, ma'am. Two persons, one is Johul Islam, other one is Jahidul Islam.
Other is Zahidul Islam.
Jahidul Islam.
Jahidul Islam.
Islam. The punto paragraph of this one, okay?
Jahidul Islam.
What position? Section, what is this? ইয়েতে আছে বলে।
It was given to Elijah Khatun. Her signature is also there.
Let us,
Elijah Khatun.
let us know. Elijah Khatun.
Hmm.
It is 47 or
Her
48.
signature is also there, 47. 48. 48 notice.
Elijah Khatun, anything more, madam? One Elijah Khatun, wife of our daughter of?
Wife of Jahirul Islam.
Wife of Jahirul Islam. And other one, madam, about Jahidul Islam.
It was given to Jahirul Islam, son of Raizuddin Ahmed.
Jahirul Islam, the other one, son of
Raizuddin Ahmed.
Raizuddin Ahmed. It will be about, it is number 1, it is number 2.
So in this case, it seems there is compliance.
Madam, in my if I
36,
if I say, now
Yeah.
question is,
No,
suppose.
You are right that 36 is not complied with,
So,
but 36 is not complied with if you read in isolation. But if you read 36 along with 48, then there is a compliance of 36. But that is the thing that has to be decided by this court.
that might way to read my lord, because in this, what I do my lord about the Dikebuzu's case. That is what I'm.
No, that
Your lordship.
that is the decay. Mr. Chaudhary,
Yes.
that I am very clear about this. If 48 is not there,
Yes.
then 36 violation reading along with 62, I have passed plenty of judgments.
So many orders.
Plenty of, there is no problem at all. But in case a person is there, a family member or a nominated person, and he is there present, but his signature was not taken in the arrest memo, but 47, 48 notice was given. In that case, what will be the situation? That has to be decided. That I will decide.
Then 36 matter one is now why 36 then? Suppose 48 is complied.
No.
Nothing, no signature at all.
No,
Nothing at all.
48 will not do because there is
Communication may come.
36 says a responsible citizen also or family member.
Oh,
If family member is not there,
yes,
he'll have to take a
so
responsibility.
nothing is done. You have not done nothing.
Nothing here.
Not the signature of the accused.
Correct.
Nor signature anybody else.
Here
So
nobody.
whether this might not, whether it goes violation of 36 or it will rectify by
But
section
Mr.
48.
Chaudhary, you said that you also said that reading 47, 48 with 36. Then
I said if family member was there. Now we cannot say madam.
If family member is there, if from the record we find that family
That is what
member
I'm
is
saying.
there, family member is there
Yes.
at that point of time,
That I'm saying.
then maybe a different.
That is what I'm saying. But another thing comes, suppose just another interpretation may also come. Now with regard to my case, I am saying not that way. Now 48 complied, right? Now then what is the purpose that is no signature accused also not there, man. Signature accused also not there.
No, see, accused there.
No, 36, my lord.
36 accused there.
Accused signature is not there.
Accused signature is there.
No, my lord.
Accused signature is
No,
there.
no. Nothing. Date is also not given, mine. Page 43, your lordship will see.
Accused signature is not there.
No, not at all.
No, it is there, Jahidul Islam.
Oh. Your page 43, your lordship?
Oh.
Page 43 and 45. Oh, record your lordship is for the record, my lord, original record.
No, you have, there is no signature. No signature means there is no issue of 36 notice. He's correct in that. There is no signature, madam. There is no signature. I mean, there is no signature means this court has already passed the judgment saying that there is no signature. That means there is no 36 notice memo at all, arrest memo at all. There you have a ground now. We'll pass the order. But we got your assistance. Good.
No matter that part also you should be sure, man. That is very important. Very important, very important, man.
But 36 without signature of
That is what I'm saying, man. That's why I said now I come to my case, man. That's why I placed, man.
Subject to correction, Lordship, whether non-compliance of 36 will amount to grant of bail, that regard, I'll place some judgment.
No, not required. No, we have already taken a view. This court is not going to change it. 36 non-compliance is non-compliance. If you do not take, I mean, madam, if you do not take the arrested person's signature in the arrest memo, and if you want to come up with and say that I have some case laws to compliance, there is no compliance at all. This court cannot be convinced with that.
So far as 47 and 48 is complied with, Lordship.
48, 47, forget it. 40 to 36 is the main document whereby you arrest a person. Those are supplementary documents. Arrest memo is the main document. DK Basu case was discussed only on that. And if you do not take the signature of the, and what action you are taking about your these officials?
Sure.
What action your department is taking on these officials? These police officers? They do not know about this arrest memo signature has to be taken. They should be dismissed. They should be immediately dismissed.
Otherwise, Lordship, whether it is in case of both the accused persons.
Both the accused persons.
Signatures.
Yes.
No, no signatures. are there.
Petition now, page 43, 45. No, next close.
See, after passing of the case of DK Basu long time back, CRPC has been amended. So much of police infrastructure has been made. So much of trainings have been given to the police officer, and still they do not take the signature of the person in the arrest memo. This is the total violation. We'll pass the order. Right now, Mr. Vichar Chaudhary, Learned Senior Counsel, assisted by also heard MS SH Majorika, Learned APP for the state. You said something, but 36, what you said?
If 47 and 40 is duly complied with, then whether the mandate of 36 is.
We can give a case but this court is fully convinced that 36 is the primary document for any kind of arrest, and these are only supplementary documents. So 36 is violated if it is violated. 48 is that's why we have discussed so much and taken his time also. That if 48 is complied with, then maybe 36 is complied with, we can say so, because intention and object of bringing in 36 is complied with if 48 is complied. But if signature of the person is only not the arrested person, then how it will be?
Yes.
We'll pass the order.